Kia ora koutou and good morning everybody. Welcome to hearing 22, the topic being infrastructure. I think what we'll do, there's a few reasonably new faces to our process that are here today. So on that basis, I think we'll just do a little bit of a conversation about how things have worked and how this hearing will run. I think I'll start though by introducing the panel who may or may not be familiar to some or all of you. Phil Mitchell is my name. I'm an independent hearings commissioner and planner based here in Auckland. I'll ask the rest of the panel to introduce themselves as well, please.
Hello, I'm Diane Fulton. I'm a former councillor and independent commissioner.
In Morena, Janet Gibb, a current councillor and independent commissioner.
Kia ora koutou, my name is Linda Te Aho and I'm an independent hearings commissioner.
Yes, good morning everybody. Paul Cooney's my name. I'm a lawyer from Tauranga and I'm one of the commissioners.
Thanks everybody. I'll ask those that are attending the hearing to introduce themselves in a moment and also have the opportunity to discuss anything relating to procedure if there's anything in that space that needs to be raised. But just by way of a few ground rules, if you like, for how we've been running these hearings. The first one is when you're not speaking, if you could please turn your microphone off, which I notice that most of you have done, and then turn it on when you are speaking. That way we avoid feedback and it just helps the stability of the connection. Noting that we've had virtually no problems with these Zoom hearings in terms of the technology in the 7 or 8 of them that we've run thus far. Second of all, the proceedings are recorded, both by way of video and by audio recording, and they're available on the council website at the end of the day. For those parties that have produced expert evidence or legal submissions, we are requesting that those parties provide a highlights package of the material that's contained in that information. We have read it. In relation to this particular hearing, that's been a reasonably daunting task because there's a large volume of material given the breadth of this particular chapter. But we're not kindly disposed to people reading vast chunks of their legal submissions and or vast chunks of their written evidence. That's the reason for the witnesses that we've requested that there be a short highlights package pre-prepared. And for those of you that have prepared that, we're appreciative of that. For those of you that haven't, we just remind you that we have issued directions about what we require in that regard. In relation to the what I might call the lay submitters, that's individuals that have presented submissions either on their own behalf or on behalf of their family or possibly themselves and their neighbours or whatever that case may be, and who haven't presented expert evidence. We have read the submissions that you have filed earlier in the piece when the plan was notified, and your further submissions if you've made those. And we've also read the section 42A responses to what you have raised. So we're very keen in relation to you that are not familiar with this proceeding or these proceedings to just focus on what it is that your concern is and what it is you want the panel to do in terms of the decision it makes on the proposed district plan. The thing I'd also say in that respect is that the section 42A report that's been prepared and the rebuttal versions of those documents are simply staff and their advisors' recommendations to the panel. They're not binding on us. We will hear all the information that's presented to us, including that, but not confined to that, obviously, and then we'll make our decisions based on all the information that's in front of us. I also want to say to those lay submitters that may not be particularly familiar with this process, to try and be as relaxed as you can, even though this is semi-formal and I don't know if the Zoom technology is familiar to everybody, but just treat it as if you were sitting down having a conversation to us, telling us what it is that you're concerned about and what you want us to do. It's not our style or approach to leap down anybody's throat and start challenging what's being said. We will simply want to listen to what you've said and ask any questions that we have if we don't understand something that you've explained to us. Like we might say, well, we don't quite understand where your back fence is. Can you show it on the diagram that you've got, or something along those sorts of lines. So for those of you that aren't familiar with this, please try and be as relaxed as you can, because we're not going to jump down anybody's throat. We're scheduled to finish midday-ish tomorrow, but that is a little bit in the lap of the gods. We'll take as long as we need to take to run through everybody's presentations to us. The only thing that we will do is that if people are starting to get repetitive and starting to say the same thing for the second or third time, we'll just remind them that we have heard that and that we will move on. The final thing I want to say is that the hearings panel, given its experience in dealing with matters around this district, has prepared what's called a register of interests. That's been available on the council website for approximately 12 months. And that sets out the relationships that some of us have had with people that have made various submissions on the district plan. In some cases, those relationships are such that those relationships are noted. In some cases, the relationship is sufficiently close that individuals of us will take no part in the consideration of certain submissions that relate to those particular parties. In my own respect and in relation to this hearing, my firm acts for Genesis Energy, and Mr. Matthews, one of my colleagues, is presenting evidence on behalf of Genesis Energy, and naturally I'll take no part in hearing or deliberations on his material. And the panel, as we go, when there's a particular submitter or matter raised, will identify any such conflicts or register of interests as we go. I won't do that now. We'll do it in due course as we proceed. So I think that's all we want to say by way of introduction. Is there anything that the panel would like to raise before we commence that I haven't covered? That's good. It seems not. What I will do is I won't go around and ask individuals to introduce themselves by me pointing at them. So one, I can't point other than at my screen, and secondly, if I say what your name is, it sort of defeats the purpose of you introducing yourselves. So if we could just go around the table for those parties that are representing clients, that are presenting witnesses. I don't think we need to hear from the individual witnesses. If counsel or the leader of that process can just introduce themselves and the team that's present, I think that will suffice. So let's go around the virtual room, and if people could introduce themselves, please. Maybe we can start with the council staff that are present.
Morena, my name's Fletcher Bell and I'm the District Plan Administrator and the Hearings Coordinator.
Thanks, Mr. Bell.
Morena, I'm Carolyn Rett. I'm a policy planner assisting the council and basically tasked with integration across the district plan.
Thanks, Ms. Rett.
Good morning, I'm Trevor Mackey. I'm the Section 42A reporting planner. I'm a planning consultant to the council.
Thank you, Mr. Mackey.
Morning, my name's Will Gauntlet. I'm the District Plan Manager at the Waikato District Council.
Thanks, Mr. Gauntlet.
Morena, my name is Sandra Kelly. I'm the Senior Project Coordinator District Plan at the Waikato District Council.
Thanks, Ms. Kelly. I think that's the council team. We've also got Ms. Singh, if you could just introduce yourself too, please.
Oh, hi everyone, my name is Suki Singh and I'm a consultant planner to the panel.
Thanks, Ms. Singh. Right, that's the council team. Maybe we can just go around the room and the various submitter parties could identify themselves, please.
Richard Matthews, I'm, as Dr. Mitchell mentioned, presenting evidence on behalf of Genesis this afternoon.
Thanks, Mr. Matthews.
Good morning, everyone. I'm Brendon Liggett. I'm submitting 694, or submission 694, which is removal of the Redwood Grove indicative road.
Yep, thank you. Thanks, Mr. Graney.
Morning, everyone. Mark Arbuthnot, I'm a planner for the Ports of Auckland. I'll actually be on tomorrow afternoon or tomorrow morning. So I'm just listening to the opening remarks and maybe drop in later on this afternoon.
Thanks, Mr. Arbuthnot.
Morena, I'm Miffy Foley, and I'm representing Waikato Regional Council, and I'll be presenting later this morning. Thank you.
Thank you, Ms. Foley.
Good morning, Christina Sheard from Denton's Kensington Swan, representing Waka Kotahi, presenting later this afternoon with 3 witnesses. Thanks.
Thank you, Ms. Sheard.
Well, I'll go next. Douglas Allan. I'm here for Kainga Ora. Alex Devine from my firm, Alice School, will also be watching in, and we have 3 witnesses presenting tomorrow morning, I think, by program, but sort of towards the end of the list.
Very good. Thank you, Mr. Allan.
Okay, do you hear me now, sir?
Yes, we can. Thank you, Mr. Dromgoole.
Yeah, sorry, I was getting used to this technology. Good morning and thank you all. I'm Simon Dromgoole, lay submitter on behalf of myself and my family, landowners at Tuakau.
Thank you, Mr. Dromgoole.
Good morning, everyone. My name's Phil Stickney. I'm a consultant planner with Becker based in Auckland, and I'll be presenting evidence on behalf of Kainga Ora tomorrow morning, just listening in this morning.
Thanks, Mr. Stickney.
Kia ora koutou, I'm Tertia Thurley from the Department of Conservation, presenting evidence this afternoon.
Thank you, Ms. Turley.
Good morning, can you hear me?
We certainly can. You must be Ms. Hanram, if I've pronounced it correctly.
Hanrahan, yes, colleague.
Oh, Hanrahan, sorry, it's been written down on my sheet wrong. I apologise.
Yeah, it's a typo. That's fine, it's common.
Thank you and welcome.
Lynette Wolf for Horticulture New Zealand, presenting tomorrow afternoon.
Thank you, Ms. Wolf. I think silence must mean that other people here are either just observing, which is obviously their right, or they're witnesses for one of the parties. So I think without further ado then, we'll commence, and we'll start with the Council's Section 42A report, which I think you're going to present. Thanks, Mr. Mackey.
Good morning, Chair and Commissioners. I do have a brief opening statement, but I won't read the whole thing. I'll just go over the main points and then indicate where I'm passing over sections of it.
Right, thank you.
The topic of infrastructure and energy received 1,316 original submission points and 1,301 further submission points. It was quite extensive coverage of the chapters on infrastructure. Many of these submissions were from infrastructure providers, but there were also submissions from community and public interest groups, iwi, affected landowners, government agencies, the regional council, land developers, industry, and a substantial submission from Waikato District Council on errors and omissions. Many of the submitters supported parts or all of the proposed objectives, policies and rules for infrastructure and energy, However, there are also many requests for detailed changes to the provisions. So the Section 42A report sections D0 up to D13 are set out to work sequentially through the proposed district plan, chapters 14 and chapter 6 provisions. That's the rules and then the objectives of policy. So the focus of this opening statement is on an overview of the key matters which remain as points of contention. So first of all, within my opening statement, paragraph 5 onwards, that's a summary of the changes that have already been recommended through the Section 42A report, and there are extensive number of changes as the submissions went into a great deal of detail. The rebuttal evidence that I lodged in response to the submitters' evidence that had come in also attempted to resolve some of the matters of contention by recommending further changes. And in summary, those are from my paragraph 33 on low impact stormwater management, where a matter of discretion is added. In significant natural area vegetation management, where a matter of discretion is added. Confirmation of policies and provision of rules for regional flood protection infrastructure. Identification of the national grid in relation to identified areas, and confirmation of the subdivision corridor width for the national grid. A recognition of renewable energy generation, provisions for the Huntly Power Station, and a definition for amateur radio configurations. There are higher order policy directions which direct how some of the provisions of the proposed plan need to be written. The Resource Management Act Section 6 matters of national importance has resulted in amendments being recommended to some objectives, policies and rules to recognise and provide for those matters of national importance in relation to infrastructure within identified areas. Identified areas are the areas of high value that are identified within the plan. There are national policy statements which have resulted in amendments being recommended in the report to some objectives, policies and rules. The plan is required to give effect to those national policy statements, such as the New Zealand Coastal Policy Statement, the National Policy Statement on Electricity Transmission, National Policy Statement on Renewable Energy Generation, and the very recent National Policy Statement on Urban Development. The Waikato Regional Policy Statement provides an overview of the resource management issues in the Waikato region and the ways in which integrated management of the region's natural and physical resources will be achieved. The proposed Waikato District Plan is required to give effect to the RPS. So amendments were recommended within the Section 42A report to some objectives, policies and rules to better give effect to that regional policy statement. The proposed Waikato District Plan objectives are required to be the most appropriate way to achieve the purpose of the Act, and the policies and rules are required to be the most appropriate way to achieve those objectives. The remaining matters of contention, there are several matters. They comprise a number of types. One is the key matters that are addressed in my rebuttal evidence. The second is matters that are subject to the submitter's evidence, to which I recommend no further amendments, and you have witnesses before you on those. And there are other matters with which I, in my Section 42A, recommend not accepting the submissions and on which the submitters have not provided evidence that may appear at the hearing, and we do have some of those at the hearing today. The key matters that remain in contention of that first sort on which I've prepared rebuttal evidence are noise-sensitive activities in the State Highway Rail Corridor. There are witnesses here on that today from NZTA Waka Kotahi. Kiwi Rail and Kāinga Ora. I submit an amended version of the NZTA Kiwi Rail proposal, but the NZTA and Kiwi Rail seek further controls, and there are other submitters opposing those provisions. Second issue is the National Grid subdivision corridor, and there'll be evidence from Transpower from Kāinga Ora. I support the Transpower National Grid subdivision corridor provisions, but Kāinga Ora opposes their physical extent. The third significant issue are the telecommunications provisions and identified areas, and you'll have evidence from Spark, Vodafone and Chorus submitters on that. I support the identified area protections, but the telecommunications network utility operators seek amended or more permissive provisions. The second group of matters that remain in contention, which were covered in the Section 42A report, are those where submitted evidence is provided, and I do not propose further amendments. Some of these submitters' evidence statements restate the original submissions, and there are a number of issues there, and there are either tabled letters from those submitters for you, or they will have witnesses here over the next 2 days on those issues. The third group of matters in contention is where the submitters do not agree with the recommendations in the Section 42A report, but have not provided evidence. And those submissions may be presented with supporting information at this hearing. I note that the hearing schedule includes submitters in this category on the topics of indicative trails, indicative roads, vehicle access site and separation distances, and vehicle access widths. This concludes my opening summary of the infrastructure and energy topic. I look forward to the evidence presented at the hearing for the next 2 days and welcome any questions that the panel may have.
Thank you, Mr. Mackey. I'm sure the panel does have some questions. This is a big topic and covers a lot of ground. So can we perhaps start with you, Mr. Fulton?
Sorry, I was on the wrong place. Thank you. No, I don't think I've got any specific questions this time. It's just a very large topic, and I can understand how difficult it might have been to put it all together, but no questions. Thanks.
Thanks. Ms. Gibb?
Yes, thank you, Mr. Chair. I don't have any questions at this stage. I may have some as the presenters come along, and thank you very much for putting it all together. It is a large task. Thank you.
Thank you. Ms. Te Aho?
No, similarly, I don't have any questions at this moment. Thank you.
Mr. Cooney?
Yes, just a few questions, but I'll probably come back to you later when you have your reply. Firstly, sort of as a general comment, where you've got an issue about technical dimensions and technical issues, how do you like the diameter of a structure pole and that type of thing, which is beyond our expertise, how do you propose we deal with that?
Some of it is by comparing how it's being dealt with in other jurisdictions. So we see how other plans, district plans, have been able to deal with those. Some of it will come from the utility operators who can provide evidence about the actual structures that they require, the ones that they have in place, and the types of technology that they're using. I think there's probably another principle that we need to be enabling of infrastructure. And so it's no longer a matter of, I think, saying any infrastructure is unsightly in the landscape and in the urban environment, and so we should avoid it occurring or try and hide it. It's a matter of being realistic about being able to make provision for it to occur, particularly the day-to-day provision and operation and maintenance of infrastructure, and to really limit the controls to making sure that that enablement of the infrastructure is not going to have any significant effect.
Yeah, okay. Well, it's something we might come back to. And as an example, I think there was in your report a discussion about the width of antennae dishes and things like that. Well, you know, that's sort of outside our expertise as to what are the correct dimensions and so forth. So I just raise that as something we may come back to on at the end there, where there may be a bit of a dispute between some parties or in respect of your recommendation. Just moving on from that, just on the noise sensitive activity rule being promoted by yourself in answer to the submission from NZTA and New Zealand Rail, what section 32AA analysis did you actually conduct? What I saw was sort of a 3 or 4 lines. Did you, behind that, did you actually carry out an analysis? Or did you just adopt what NZTA put up? I only did a very high level analysis. That was only that 3 or 4 lines. And within that, I acknowledged that there are quite significant costs to the implications of the rule. But I did rely on the proposal from the submitters being demonstrating the necessity of the rule, and the evidence that's been provided will include a section 32 analysis of the proposal and a costs analysis of it as well. But I think further section 32 AA analysis would be needed to before you could make a decision on that. Okay. Well, just further on that point, did you check and see the number of complaints over the years received by council on noise from rail and road?
No, I did not check the council's complaints. I have previously come across the Kiwi Rail complaints register, and I understand that NZTA have also received many complaints and used that as a basis for recognising there needs to be management of that reverse sensitivity issue.
Have you worked out the number of houses, existing houses, that may be affected by this rule in the Waikato district?
I have not, although that appears in the evidence of Mr. Grala for Parkmere Farms, and he did a GIS analysis, although it's really just an assessment of the number of properties that existing properties that are within that 100-metre distance of the state highways and the Kiwi Rail corridor, and it doesn't have any real assessment of what existing noise mitigation there is there, either through landscape or noise barriers or surface treatments of some of those new roads like the Waikato Expressway. So it's really a raw measure of the existing areas, which for new works, NZTA is required to provide that noise mitigation for them.
Yeah, okay. Yeah. And did you do your own the cost of the mitigation per se? Did you carry out your own analysis? I know NZTA have presented a report, but and that was something like 16,000 from memory for a new house. Did you check that and see, carry your own analysis out or anything?
No, I did not, although I did acknowledge that there is going to be a significant cost. And I think the NZTA analysis from a quantity surveyor identified that it would be somewhere between 1% and 2% of the cost of a new house, whether that's provided at the subdivision stage as noise mitigation or bunding or noise barrier for the whole subdivision, or whether that's provided at the development stage as acoustic insulation and mechanical ventilation of the new houses.
Well, that seems to be sort of an abstract figure, isn't it? Don't you have to translate that into, what the general estimated physical costs are going to be, in terms of dollars, to get an idea of, well, what's this going to impose on if you're going to build a new house rather than 2% of whatever the end cost is, or what? Isn't there a difference there?
I think it's more about the range of costs that are likely to be involved. If you have any change of level of the land in topography, if you have any significant landscape planting, and if you have any distance between the boundary of the road or rail designation and the actual tracks of the road, then that has quite a amount of variability on the cost that's going to be involved. Also, building code requires fairly substantial construction of new houses in any case, including double glazing and insulation for heat transfer, which also means modern houses are more acoustically efficient as well.
Mm-hmm. Tell me, how do you put in place vibration mitigation measures? What sort of work's required there? What do you do? Do you have to have a foundation change or what?
It is more substantial foundations, and there's one provision that's given within the suggested provisions for how to achieve that, although it's given only as an example and may not be suitable or economic for a single-storey new house. But yes, the main implication is for more substantial foundations, and particularly the Waikato has extensive areas of peat soils, and so that will have an impact as well on how vibration can be managed in new building.
Have we got any cost analysis, physical cost analysis on vibration alterations or mitigation?
No, only that the one that was proposed within the provisions, but it is really only a matter of more distance from the road or the track, or the closer you get, then the more that is required. So
yeah, I didn't see, and I could be wrong, but I didn't see any costing for a vibration mitigation. Is that right? Am I right?
You're right, there's no cost given. No, that's correct.
Thank you.
Thanks, Mr. Cooney. I've got some general questions in relation to outcomes, and then I've got quite a number of questions around drafting that I think I'll use a selection of to identify some themes rather than go through them all one by one. Because one of the things that I want to flag now is that irrespective of merits arguments, I've formed the view that there's some considerable improvements that can be made to the drafting of these provisions, because a lot of them are sort of fairly waffly objectives and waffly policies that have inserted bits and pieces from here and there. And I mean no criticism in saying this. You know, there's relief that's been proposed by a submitter, and it doesn't actually flow from the theme of the objective and policy. So one of the things that I think we're going to be thinking about as a panel is leaving aside the merits of the various positions that the parties take, is just the process to get this very complicated chapter into really good drafting shape. And as I say, Mr. Mackey, it's been a huge job getting to this point, but we're very keen to get it to the very end and give it that level of polish that we think it needs. The questions that I want to ask you of a sort of an outcome nature. The first one relates to your default category in a number of events, default activity status of non-complying, for example, in earthworks and SNAs for upgrading the national grid and so forth. The evidence of those that oppose those sorts of provisions say that's very tough, you know, and that you've got strategic lifeline infrastructure. And because you might need to do something associated with it that's a bit bigger than contemplated, or it's slightly outside the scope of what the plan says, you default to non-complying activity status. Can you explain what your rationale for that is, given that we're not talking about, you know, inconsequential infrastructure assets? We're talking about things in the most part that are, as I say, lifeline type infrastructure.
Yes, I do take the point. I've been uneasy about the degree to which non-complying activity is used for infrastructure, and have tried to only make it in relation to those higher valued areas. And there are many cases or reasons for functional operational purposes why infrastructure needs to go into those areas. And the reason for being non-complying rather than discretionary is, I think discretionary makes that decision for us that they're authorised to go into those areas without having to take full account of the values that they may be affecting. Whereas the non-complying indicates that if they can be avoided, then they should be. And if they do have to go in there, then the infrastructure objectives, enabling objectives and policies should be able to achieve that in the assessment of the non-complying activity. And this will probably come through in evidence of water care in relation to wastewater treatment plants and water intakes being able to locate, and reservoirs being able to locate on the top of hills and next to the river.
Right, I may come back to that when we go through some specifics. But the second one is in relation to the Horatau Inland Port. Mr. Arbuthnot's evidence is to the effect that the provisions that are now being proposed in relation to that proposal and in relation to ITAs and traffic management and so forth, that creates a significantly higher degree of control over activities that have already been through a substantial RMA process prior to this, to the point that he's saying that what's now recommended is out of whack, if you like, with those previous decisions. What's your comment on that?
Well, those are not my recommendations. My recommendations are that the inland port at Horatau be enabled, that it be given a specific vehicle generation rate, which has already been identified by them in its establishment. And I'm also recommending that the ITA, or Integrated Transport Assessment requirement, really only be a further information or level of information that would be required with a resource consent rather than it being written in as a rule, which is what's being sought by NZTA.
Right. All right, thank you for clarifying that. Coming back to the noise buffer in relation to the state highways and Kiwi Rail, Kāinga Ora have identified a couple of examples where the proposal that's in front of us, not from you, but from the proponents, has been rejected. And I think they mentioned Auckland and Whangarei as examples where it was proposed and not adopted. Are you aware of any other examples where that approach either has or has not been adopted, and what is generally done elsewhere around the country?
I have heard that it's been proposed in many jurisdictions, many plan reviews and plan changes, and in some cases it's been adopted in varying forms, but possibly more as a means of mitigation, that the plan changes may not have been able to proceed if the landowner or the proponent of the plan change had not offered them up. And I think you'll see some provisions like that in the plan change 20 for the Waikato Operative District Plan, which was, I think...
That's Lakeside, you mean?
That's right. And also in, I think the question should be put to NZTA witnesses because they will have far more recent experience. I think there was within the Bay of Plenty, and I think Gisborne and Whangarei may have been the most recent cases where they've been proposing these provisions. In Auckland, they have been included in some plan changes for rezoning plan changes which are close to the bus stations or rail stations for intensification, where obviously those locations are going to be subject to vibration and to noise of those areas.
I think the point that Kāinga Ora makes is that they're all sort of one-offs and geographically quite specific, and may well be warranted given the circumstances that relate in that individual location. But the approach being taken here is much more, what's the word, extensive than that. I mean, it's district-wide provisions. Do you have any comment on that?
I think partly is the increased use that's going to be made of this type of infrastructure, the rail and the state highway network, heavier traffic, a more frequent traffic, and the provisions as they were originally proposed by NZTA and Kiwi Rail, I think, were more severe, and some of the submitters have identified them as saying there's not allowed to be any development within 100 metres of these, and so maybe they should buy that land rather than treat it this way. But I think I've tried to amend the provisions so that that corridor really identifies the need for mitigation within it rather than the saying there's no development allowed. And the same way with subdivision, to not say there's not allowed to be a building platform within this distance from the rail line, but rather to say if you are proposing building platforms within this area, then you need to either do some land mitigation of the noise to make your land suitable for that type of development, or you need to foreshadow that the houses will need to have particular treatment to them when they are constructed.
The provisions don't quite give that level of guidance though, do they? They do set, for example, or propose at least, acoustic standards for the inside of dwellings. You know, and I can see how that's something that you'd be directing, you know, quite directive in terms of a district plan provision, to say if you're close to these railway lines or state highways, then you need to double glaze all properties if you're closer than X amount of distance. I get that, but the provisions are pretty open-ended and put an awful lot of onus on property owners to mitigate the effects of a state highway rather than considering the other way round. And the one that immediately springs to mind is that the one way of addressing this would be to include those buffers within the designation that applies for that infrastructure. That would internalise the cost, and this issue has arisen at other hearings that we've had in this process. And the answer from the infrastructure providers is that's too costly. And I guess we look at that and say, well, we understand that that's the case, but absent the counterfactual, and say, what is the cost that imposes on the community wanting to utilise their land? I think we are forming the view that there's a bit of an information gap in that regard. And it just seems that we're left with a very, very complicated process for people wanting to use their own land, with a set of provisions that aren't necessarily as directed towards the sort of mitigations that you're talking about than they are around, protecting the corridor and those sorts of things. And don't get me wrong, I'm not saying that we shouldn't be protecting corridors for key infrastructure, because I'm not suggesting that at all. But I'm just asking you the question as to whether you think we found the right balance between public good and private cost in terms of finding that endpoint.
I think you're right, it is a matter of trying to find a balance, and it is that enabling that regionally and nationally significant infrastructure to operate, and to look at the balance of where those costs fall. And we've seen up to now that if you change or put in a new state highway, expressway, or increase the width of and intensity of the rail line, then those operators have been required to meet standards in relation to existing development, which in some cases has meant having to rebuild parts of those existing houses, and in other parts has meant creating noise barriers and bunding, and sometimes distance and pavement surfacing of the roads to keep the noise down. And in some other cases, from complaints, that's had to be retrofitted to them. And that's why the implication of the rules, proposed rules, is really for future development rather than trying to readdress the balance in relation to existing development. Yes, alterations and new buildings within existing settlements will be subject to these provisions, but the main focus will be on the growth areas, the expansions of the towns, and intensified development close to the state highways.
Okay, thank you. I just want to go through some of the drafting issues, and I don't want to. We could be here all day on that, and it's not my intention to do that. But could you just bring up or have handy your copy of the original 42A report, Chapter 6, Objectives and Policies? Because I just want to, and I know some of them have been changed, and I may come to some of the specifics of that later. But I just want to sort of go through a few examples there to highlight some of the issues that have emerged in my thinking, at least. Just let me know when you've
yes, I have
got it. Yes. You got it there. The first one's a very simple point, and Chapter 6.1 heading is general infrastructure, and that heading is replicated in the rules section 14. I assume that by general infrastructure that those are provisions that apply to all infrastructure, and then the provisions that follow relate to individual types of infrastructure, transmission lines, roads, etc. Is that the intention?
Yes, that's correct.
Okay. I note that in the objectives and policies, there's a lot of narrative that uses words like recognise and provide for, ensure, promote, encourage. They all have different meanings, and have you given careful consideration to the hierarchy of wording that you've used and the relative weight that various of these objectives and policies would be given relative to each other by the choice of those words?
I have given some thought to it, and in some cases I've recommended changes where they appeared to be a promotional objective and there really needed to be an achievement type of objective. But I think the way in which many of them are written are that they all have to be read together rather than seeing in advance that one will take precedence over another.
No, but when you choose a word in one objective that says recognise and provide for, and in another one you say recognise, you've automatically created a hierarchy, haven't you? Because those that are promoting the first of those two examples will say my objective has to be recognised and provided for, whereas the one that someone else is relying on only has to be, whatever the word I used, taken into account or whatever it happens to be. Yeah. So don't you have to make sure that when you look at these in the broad, that you've created the appropriate balancing of those before you start?
In some cases, those parts of the objectives come from other higher level policy directives. So those particular words are used, for instance, in the National Policy Statement on Electricity Transmission.
Yes.
Recognise and provide for this. The Regional Council uses a lot of that recognise, and I don't, and in some cases from submissions I have added words in, so it's recognise and provide for and protect or whatever where those are needed. But I don't think you can necessarily ascribe a hierarchy automatically. Yes, you're right, some of them from the words of the Act will have particular regard to or take account of, do have a hierarchy from case law as to what that actually means. But I think there's still a necessity to give effect to those higher order policy directives where they do apply.
All right. Dealing with objectives generally, I mean, my understanding has always been that an objective, is essentially a sentence that sets out an outcome. Do you agree with that as a general proposition?
Yes, I do.
And if I refer you to, for example, objective 6.1.6, which is adverse effects on infrastructure, that says infrastructure is protected from reverse sensitivity effects, and so on and so forth. So you'd agree that that's an appropriate and well drafted objective because it's clear in terms of the outcome it's seeking to achieve, and that is infrastructure is protected from reverse sensitivity effects. You'd agree that that would conform with the norm of what an objective should do and should say, leaving aside the merits of whether it's the right objective or not. I'm not talking about what it contains. I'm talking about the way it's drafted.
It is, yes, you're right, although I don't want you to lead me into saying that therefore what proposed to write is wrong because it adds another clause.
No. I'm not being critical of the drafting. I'm saying I just circumscribed what I said by not reading the rest of it that followed. But that's objective 6.1.6 as drafted is the sort of objective that you'd expect to see in a district plan. It conforms with normal drafting convention. Yes. But then when we go into 6.1.8, and this hasn't been one that's been changed because there's been no submissions on it, so there's no criticism of anybody. But infrastructure takes into account the qualities and characteristics of surrounding environments and community well-being. several things that occur to me with that is that, one, it's waffle. Second of all, infrastructure can't take anything into account. It's the people that design it that do that. You know, infrastructure can't take into account qualities of something. I mean, it's a tower or a bit of tarmac. And what does an objective like that mean? Infrastructure takes into account the qualities and characteristics of surrounding environments and community well-being. If anything, that's a policy, isn't it? Leaving aside the way it's drafted.
I think as an objective form, it's really about the design and location and construction of the infrastructure being able to respond to the environment, and particularly the more sensitive environments that it's going to go into.
But yeah, no, I mean, I'm being pedantic to say that infrastructure can't make decisions about integration with anything. That's the people that design it do, and that's self-evident. But it then says, you know, taking into account the qualities. Well, I think you've got to be very careful with the words "take into account," because that's not a particularly high threshold. And if we've got other policies that talk about recognising and providing for, notwithstanding what you said before, which I accept, it just seems to me that a number of these objectives have been written in a way that says that they've either been picked up from somewhere else or rolled over from another document, but no one's actually read them and said, does that make sense? And saying, one, is it an appropriately worded objective, which in my view 6.1.8 isn't? And second of all, is it written in plain English in a way that isn't just waffly? What you explained made much more sense than what Objective 6.1.8 as drafted does to me.
Yes, I do agree with you that the ones that weren't able to be changed within the scope of submissions, the objectives do appear to have been brought together without an overview of how they relate to each other.
Yeah, okay.
There's only limited scope to be able to address that within a redrafting of them.
Well, we've got a national planning standard, and we've got pretty broad submissions on a number of topics. But this panel's already expressed at other hearings that if there's things that are just poorly drafted in a way that makes no sense, just because there's no specific submission that says please fix policy X, we're not going to shy away from fixing it if it makes it clearer, drafted better, and that there is a general submission that we can hang it off. Otherwise, we end up with a hodgepodge, and we're not really keen on doing that.
Yes, I quite agree with that. I'd support that approach. And many of the submissions have a clause to them which asks for any consequential amendments or any other changes that are needed to give effect to the submission. So I think that would provide quite a bit of scope for further changes if you desire to make them.
Okay. Okay. There's a few more examples I just want to highlight because can I now refer you to your rebuttal section 42A report for some other examples and focusing more on the rules?
Yes, I have that.
First one's on page 11.
Yes.
And this is RD1 in paragraph 28, relating to stormwater systems. And you've said that the blue new D in RD1 in paragraph 58 says that the discretion is restricted to use of low impact design principles and approaches. That's not a matter of discretion as such. That's got to be something. If that was a matter of discretion, it would be to say the extent to which low impact design has been used, or because it's almost like a performance standard as written, isn't it?
Well, this RD1 kicks in when a low impact design approach is not used, which which is the permitted activity standard. So if you don't propose to use a low impact design for stormwater management, then you become this RD1, and the part of the discretion is why can't you use
no, I understand that, but it doesn't say that. That's not written as a matter over which discretion is reserved. It's got to say something like the extent to which, or whether or why not it hasn't been adopted, or something to that effect. It's just a statement. The use of low impact design principles and approaches isn't a matter of discretion, it's a statement of outcome.
I think the discretion would be exercised in whether the decision maker requires greater use of low impact design principles.
But that's exactly my point. It's not about the merits of whether they should be referred to. It's about how it's drafted. And I would take the view that that's not a matter of discretion as drafted at all. Because you look at the other matters of discretion as the likely effectiveness of a system. Well, that's a matter of discretion. C, the potential for adverse effects. That's a matter of discretion. But D is not a matter of discretion. It's a statement. It's a standard. Anyway, you've provided your view. It sounds like we may disagree on that.
Well, maybe a little bit further on that. I accept that matters of discretion should actually provide guidance as to the outcome that's expected. I'm not sure that saying the extent to which is, and that's used quite commonly, I'm not sure that's sufficient, because you don't know whether you want a greater extent or a lesser extent, but certainly I agree with your point that there should be guidance there as to what.
Yeah, okay, that's fine. We agreed on that. That's fine. Let's move on. Can I, in page 12, proposed rule P5, paragraph 32. Is there any reason for having the word all in the second line? Trimming and pruning of trees and vegetation necessary to protect all overhead electric lines. That's sort of almost written like a policy position. The permitted activity is trimming and pruning of trees that affect the lines, isn't it? Doesn't matter whether it's all or some.
Only that it's a permitted activity in relation to protecting overhead lines, no matter what their scale. So the house connection overhead line, service connection overhead line, and then the lower level distribution lines are protected as well as the heavier transmission line.
Okay. Probably more importantly, in further down in that same rule, there's number 2, which is any trimming, maintenance or removal of vegetation required for the safe operation. Is that meant to be conjunctive or disjunctive with 1?
It's meant to be conjunctive, but it's mainly to add in the potential fire risk category for allowing the work to occur.
But would you, just to be clear, if you were relying on 2 because you've said there's a fire risk issue and you need to trim these trees, you still have to comply with 1? Or does it override 1?
I think it's separate, so it doesn't have to also comply with 1.
The way that the rules are written generally, though, say you've got to comply with all of them in order to be permitted. So if the intention is for 2 to be an either or, that if you're in category 2, you're permitted full stop. We probably should say that, shouldn't we?
Yes, I think that could be added for clarification. I think in some cases, the activity-specific conditions identify separate activities. For instance, say, not within an identified area, so that's a particular class of the activity.
Okay.
But yes, I agree for clarification that should be identified as it could be a separate activity.
Okay. Flick the page to page 14. And I'm just using this as a for instance, and that this originally was a policy around the provision of adequate infrastructure in the Broad. And as a consequence of submissions, and again, there's no criticism implied here, but the policy now reads much more like a flood management policy than it does a provision of adequate infrastructure in the Broad, just simply because of the weight of the wording. And I totally understand why you've done what you've done. But I guess the question is, don't we have to be careful to seek to include the relief that a particular party with a particular interest has, and be silent on a whole bunch of other factors that are probably equally as deserving? And isn't there an argument that says you're better not to have these policies that pick winners and losers or create the impression of creating winners and losers? And if you've got particular stormwater policies that you want to have, or flood management policies, you put them in the section that relates to them. Do you have a comment on that?
Yes, I think overall I agree with you that it would have been better to have a separate policy for the regional flood management infrastructure. I think it was left out of the original notified proposed plan. And I had earlier thought that the stormwater provisions would be able to cover it, stormwater and drainage provisions would be able to cover it. But when I became familiar with the types of infrastructure, I realised that it did need more significant treatment. I am uncomfortable about, as you say, picking winners and losers, that giving a higher profile to that regionally significant infrastructure of a particular type then starts to be a little jarring with the others that have not been given the same treatment. But at least it's certainly well provided for within the policy.
Can you turn now, just flick the page to pages 16 and 17. I just want to understand what's intended here, because I don't understand at the moment. On page 16, you've got, and this is again relating to flood management infrastructure, and I'm not picking on it, I'm just trying to understand what it is that's proposed. Permitted activity 1, P1, is the construction of new regional flood management infrastructure. And it specifies that it's got to be effectively close by the existing stop bank system. Then you turn over to RD1, and it talks about new capital works relating to regional flood management. I'm struggling to understand the relationship between P1 and RD1 and what applies when. Can you explain what it is that P1 is seeking to achieve, and whether, even if it does satisfy P1, it's still potentially caught by RD1 anyway?
Yes, the intention is that P1 be on the existing stop bank, or between the stop bank and the river, or around the flood channel and the pump stations and floodgates. So these are the things that are in close or on the existing flood management infrastructure.
Yes.
And that changes to it, maintenance, operation of it, and that. The RD1 is for the new ones that are not changes to the existing ones.
Doesn't actually say that though. I mean, that makes sense. I understand that. But theoretically, some of the works that are covered by P1 are arguably new capital works, aren't they?
I think the difference between them is that the RD1 would be the ones that are not within 20 metres of the landward toe of the stop bank, or on the stop bank, or between the stop bank and the river. So you default to the RD1 only when you don't meet the activity-specific conditions of P1. So
we probably need to be clear that that's the case, wouldn't we?
Yes, I think we could restate that.
Okay. I've only got a couple more. I'm not going to go on and on. Page 21. This is policy 6.2.5 relating to environmental effects. And I just want to focus on subclause Roman 6, where it says within rural environments, seeking to avoid adverse effects on some listed values.
Yes.
People that would be acting for infrastructure developers would always get nervous when they see the word avoid in a policy because of its directive nature. I think it's fair to say, and you'd probably agree with that. In this case, it says that we're seeking to avoid. And I guess there's two questions. One, what does that mean? And what's the consequence beyond seeking to avoid? You've said, well, we've sought to avoid them, we haven't. So then what happens? And I just wonder whether you'd agree with me that that policy is somewhat open-ended and perhaps could benefit from some greater clarity.
Well, actually, that's really directly from the National Policy Statement on Electricity Transmission. It's not required to avoid these effects; it's required to seek to avoid them. And that's
no, but no, I understand that. But in a district plan sense, what happens beyond? Because we've also gone, and I haven't got the NPS in front of me, but does it refer to the outstanding natural features and all those other provisions that apply, or does it just talk about seek to avoid adverse effects?
No, it applies to the high value environments as well. And I think you'll hear in evidence from Transpower that the National Policy Statement's very explicit that it's not required to avoid adverse effects.
No, sorry, I get that. But it's then you say, well, okay, we've sought to avoid them. Then what happens? There's nothing that then flows from that. And I guess my question is, should there be?
Well, I think what flows from it is that it's not going to be a non-complying activity in most cases, which if it said avoid, then you'd end up with a non-complying activity.
All right.
Yes.
Okay. I've asked you about that already. Got two more to go. Page 26.
Yes.
This is one of these examples. This is policy 6.1.4. You've inserted a new clause B, which talks about having particular regard to the benefits of renewable energy.
Yes.
The policy provisions that are above that are just have regard to.
That's
and
correct.
I know that you'll point me to the NES for renewable energy, but we still have to be careful, don't we, about the wording that we use in policies that are related, because there's an inherent hierarchy in A and B by virtue of the wording that's there, isn't there?
Yes, there is a hierarchy, yes.
All right.
No, and I think that was intentional again from the NPS, but and I think the NPS is written slightly differently to other NPSs when it comes to renewable energy generation.
Okay. Can I just finally then refer to you Appendix 2 of that same document, which is the noise sensitive activity transport corridors? Just a couple of questions around that. Is P1 refers to a new building or alteration, and that same terminology is used a number of places through the provisions that follow. Is alteration defined in the plan?
No, it's not. And in fact, I think it probably is supposed to mean addition rather than alteration. It's not meant to have anything to do with internal rearrangements or buildings.
But I mean, I wouldn't have thought that these provisions would apply if someone wanted to, replace the front door or, put a lean-to on the back or something. I mean, they seem to be very, very, the use of the word alteration seems to capture pretty much anything other than the status quo. And I'm wondering if that is the intention.
I think the intention is that it be an addition where a sensitive land use, like a dwelling, is increased in size or intensity of its use.
Okay, thank you. And further down the page, RD1, one of the matters of discretion there, and it's the last one, is the outcome of any consultation with NZTA or Kiwi Rail. Is that a provision that applies in any of the other RD rules? That the consultation, the matter of discretion is the consultation with the infrastructure provider?
I think it may come up in relation to Transpower and the National Grid, but I think this is here because there may provide for alternative solutions to be achieved.
It's pretty unusual to I mean, basically it's saying that as an activity status and as a matter of discretion, you've got to consult with the roading authority. I mean, I think we've got to be, well, I guess I'll ask it as a question. Don't we have to be careful that we're not creating some sort of de facto approval process, and in any event that we need to treat all infrastructure providers equally in terms of the obligation to consult with them rather than picking a winner?
I think you may have a point there in terms of consistency of treatment with all infrastructure providers. There are hierarchies of infrastructure at, identified regionally significant and identified nationally significant. And
yes,
there are also hierarchies in terms of their reverse sensitivity, like the National Grid having a higher level of recognition to that. I think in this case, it's because as well as being network utility operators, these are road controlling authorities or the rail controlling authority, and they have other functions as well.
Yeah, no, and that's noted, but that's in a separate statute. That's not a district planning matter. They're wearing another hat when they're doing that.
I think that's in terms of them being able to control effects of their infrastructure through consultation or granting consent to do something which would otherwise infringe a district plan rule.
Okay, all right, no, I understand that. Because I suppose the point would be, why wouldn't you have in the SNA earthworks provisions the results of consultation with Department of Conservation, for example? I mean, it would seem to me that one would have to be careful about picking a particular party for a particular sort of infrastructure to be consulted with, whereas
yes,
others aren't. I suppose that's the point.
Yes, and I also think it's quite likely it would come into a notification test in any case, whether the consultation was required or not.
Okay. All right, thank you, Mr. Mackey. I'm sorry that's been a bit laborious, but I think the panel has had a bit of a conversation before the hearing and is very keen to get the drafting aspects of this very complex part of the plan resolved. So that's really why I wanted to take you through some of that, which has probably sent most of the other parties on the call to sleep. But apologies for that. That's somewhat of a necessary evil.
Very good.
But I can see that, thank you, Mr. Mackey. I can see that Ms. Hanrahan is awake though. She's there, she's smiling. If you could turn your microphone on, please, Ms. Hanrahan, and tell us about your submission, please.
Yes, I have actually typed it up because I've got quite a few points I wish to make. So if you're happy, I'll just start.
Yep, fire away.
Okay, my name is Colette Hanrahan and I live at 126B Woodcock Road, Tamahere. We own land with an area of approximately 14 acres. Around 1/3 of this land is taken up by a steep gully, roughly 20 metres deep, extending around our dwelling and garages, equaling to about 600 metres in length. The Mangaharakeke stream runs along the bottom of our gully, defining the border of our land on that northern side. My family and I have lived here since June 2003, just over 17 years. On 16 July 2018, Waikato District Council, or WDC, notified us by letter that under the proposed district plan, they had made 2 specific changes to our property. one of them being the addition of a walkway, cycleway, bridleway designation over our property where it borders the Mangaharakeke stream. Naturally, we were very upset, worried and concerned about this proposed designation on our property. Not least to say the fact that WDC feel they can use our private land to suit their own wishes. There had been absolutely no consultation with us prior to this letter. At this point, I would like you to imagine how you would feel in this situation. Would you be happy with council using your own private land for their own use with no thought to your privacy, safety or ownership? Needless to say, we put in 2 opposing submissions regarding this proposed walkway, cycleway, bridleway. Firstly, to delete the designation from our property, and secondly, to delete the designation from Fuchsia Lane to Titoki Lane, Tamihiri, of which the designation on our property is proposed by WDC to constitute part of the Fuchsia Lane to Titoki Lane walkway, cycleway, bridleway. There are many reasons why we wish these proposed designations to be deleted, which I will now list and describe in detail. 1. Ownership of land. First and foremost, the land in question is legally ours, purchased by auction at a premium as freehold estate in June 2003. There are numerous laws, such as the Universal Declaration of Human Rights 1948, Treaty of Waitangi 1840, and Magna Carta 1215, all of which state that no one shall be arbitrarily deprived of their property. We do not understand how WDC thinks it can undermine our indelible rights over our own freehold property. Also, government introduced the Walking Access Act 2008, whose purpose is to lead and support the negotiation, establishment, maintenance and improvement of walking access over public and private land. The review of the Walking Access Act 2008, dated September 2019, states the establishment of a commission with responsibility for leading and supporting the negotiation, establishment, maintenance and improvement of access over public and private land. WDC has not encompassed the Walking Access Act 2008 or its review whatsoever, i.e. we have had no contact with WDC about the walkway, cycleway, bridleway at all. This seems very high-handed of WDC. 2. Floodplains. As I have stated previously, Mangaharakeke stream is at the bottom of a very steep gully which periodically floods during heavy rains. This happens a few times every year, while at all times the surrounding floodplains are constantly interlaced with small ponds, and you can often step up to your knees in mud. The WDC report for Tamihiri Stormwater Catchment Management Plan, March 2011, states a floodplain adjacent to a waterway or stream is flat or nearly flat land that experiences occasional or periodic flooding. It includes the floodway, which consists of the stream channel and adjacent areas that carry flood flows, and the flood fringes, which are areas covered by the flood but do not experience a strong current. The WDC is proposing to place the walkway, cycleway, bridleway right beside the Mangaharakeke stream in the midst of these floodplains. Has there been any feasibility survey as to the costs and excavations needed for a walkway, cycleway, bridleway? 3. Loss of habitat. The WDC report for Tamihiri Stormwater Catchment Plan 2011 also states that development places pressures on the natural environment. Reducing the amount of riparian vegetation can cause a loss of shading, which results in higher stream temperatures, less oxygen, and growth of nuisance organisms such as algae. Stream banks also become unstable and erode, causing sediment to enter the stream environment, thus reducing the amenity value of the area or stream. The WDC is proposing to place the walkway, cycleway, bridleway right beside the Mangahirikiki stream. Using their own references, WDC is completely ignoring the experts' advice on the importance of riparian vegetation, which directly correlates to loss of habitat. In addition, although I have found it hard to find the noted width of the proposed walkway, cycleway, bridleway, Rule 23.4.10 of the proposed district plan states that 3 metres width is required for a walkway. A 3 metre wide clearance of any riparian vegetation along the stream would surely destroy many native, not to mention endangered creatures or species habitats. 4. Conservation. As I understand it, WDC is requiring at least 3 metres width for their proposed walkway, cycleway, bridleway, as I just stated, Rule 23.4.10 of the proposed district plan. The Department of Conservation's July 1995 Managing Riparian Zones, Volume 1, states that in Section 6A, Part 2 of the Resource Management Amendment Act 1993, the preservation of the natural character of wetlands and lakes and rivers and their margins is stated to be a matter of national importance. That is, our freshwater riparian zones are of national importance. They are to be protected from inappropriate subdivision, use and development. How is WDC meeting its responsibilities under this Act, or the Conservation Amendment Act No. 2, 1993, with this amount of land clearance being needed precisely where the natural environment is needed for the preservation of our native species? Where is the concern for the upkeep and maintenance of ecological corridors for our native birds, bats, fish and creatures? 5. Duress and extra cost implications. A very pertinent article headed "Great for the cycling public, but what about the landowner?" Monday, 20 December 2010 in the Otago Daily Times highlights the duress and extra cost implication to private landowners who own land on areas where government wishes to provide walking tracks for the general public. Some landowners are harassed by cycleway proponents, causing unfair duress. If the landowner does gift an easement for the cycleway to proceed, they can then face large bills from the Department of Conservation if they need to access the cycleway to make use of their land properly. As the article says, the government appears to have underestimated the impact and costs to the private landowner and the trusts associated with these cycle and walkways. 6. Safety, theft and security. A further article entitled "Theft of Pet Sheep Leaves Twin Lambs Orphaned in Matamata" from the Waikato Times on 3 September 2018 highlights the very real concerns of safety and security for both the landowners and their animals. This family has lived on the same property for over 30 years and never had any animals stolen. Only 6 months after the opening of the public lane running alongside their paddocks, they had a ewe stolen and are now too scared to have animals in their paddocks in case of any more thefts. An even closer example is the walking bridge connecting the end of Woodcock Road and Fuchsia Lane, the Allan Turner Memorial Bridge. It had to be closed on 12 August 2018 because someone had tampered with some of the bridge's doors. It is great that this was noticed and rectified before any tragedy occurred. It is still intensely concerning that such a busy and public area can be damaged. and there is no way of finding the culprits or when it may happen again. Has there been any security initiatives undertaken by WDC to rectify this? In addition, when walking the tracks on the Tamihere Reserve on Tofuri Road, there always seems to be signs about equipment being stolen. Security initiatives undertaken by WDC to rectify this? These sorts of instances right in our backyard would scare any landowner from allowing public to have access on their land. Stock, and also in our case sport horses, are too valuable to be treated with such little care or to trust the general public with. Poor visitor behaviour is often in the news at different spots around New Zealand and disregarded or not fixed by local government or government, as the case may be. Breeding camping is the perfect example of this. 7. Privacy. The above examples I have provided you with also brings into focus the privacy a landowner would lose with a public walkway, cycleway, bridleway. To quote the Otago Daily Times article, a private person with more bedrooms than they need is never asked to take in tourists who need a bed for the night without some form of redress. As stated in the report on the findings of the review of the Walking Access Act 2008, a big concern is the loss of privacy, including concerns about people photographing and sharing images of private land through social media. Social media plays a huge role in advertising places or walkways. The South Waikato District Council had to take extreme measures to protect their local Te Waiho walkway, Blue Spring, in August 2016 due to excessive and ever-increasing visitors, creating a negative impact on the riverbed and on the banks. The walkway had received large exposure recently before this from the Stuff website. People want their photos taken in the best possible space or from a slightly different angle, which may or may not require them to open a gate that should always be closed or trespassing off the walkway, cycleway, bridleway. We all know this happens because of the more extraordinary ones that makes the news from time to time, such as getting closer to the crocodile to make the photo look better. 8. Health and safety liability. Legislation over health and safety seem to continually be changing. As I advised in my original submission, we have a lot of exotic Tasmanian blackwoods and pine trees residing along the top of our gully in places. These trees or branches periodically come smashing down. Who would be responsible if someone using the walkway, cycleway, bridleway was hurt or even killed? Or if a small child drowned in the stream? Again, the report on the findings of the review of the Walking Access Act 2008 found this to be a major drawback for private landowners. 9. Infrastructure. There are many times when I go down to the Allan Turner Walkway swing bridge at the end of Woodcock Road and see a lot of cars parked around the cul-de-sac there. With the current short walkways there at the moment, it is obviously a popular spot for people to visit, yet there is absolutely no infrastructure. No toilets, no rubbish bins, no proper car parks. WDC wants to create a walkway, cycleway, bridleway, which would end up a few kilometres long, extending from this area. Where is the practicality and common sense for infrastructure? Or would this become the landowner's problem and expense? Is this what WDC means by wanting to include the establishment, maintenance or upgrading of public walking or cycle tracks, interpretive and directional signs, accessory buildings, including those for tourism, and the definition of conservation activity in the proposed district plan? How on earth can we trust WDC to have complete carte blanche to clear vegetation, including indigenous, under the terms of conservation activity? We only have to reflect on the leaky buildings debacle or the Tamahiri ice pack fire to conclude that no council should be able to have such a large amount of leverage without any licence or watchdog to keep them in line. To be able to call this a conservation activity is absolutely ludicrous. In addition, I find the alteration of 23.4.10 subdivision of land containing mapped off-road walkways to be very confusing. As I understand it, the WDC who wishes to subdivide their land will have As I understand it, the WDC proposes that any landowner who wishes to subdivide their land will have to, other than paying for the subdivision, pay for the 3-metre wide walkway, cycleway, bridleway, then rest their land in the WDC, all the while getting no reimbursement back from WDC from their loss of land, security or privacy. How on earth does WDC expect landowners to subdivide when they're putting such huge costs on them? 10, biosecurity risks.
Ms. Hanrahan, I just need to check with you how much longer you're proposing to take, because it's starting to get a bit repetitive in the sense that we understand the point that you're making very, very clearly. You've got a written statement that would have been helpful if we could have have pre-read. Don't want to hurry you along too much, but how much longer have you got? How much more reading have you got?
I have 12 concerns and then just a little conclusion paragraph.
Okay, well let's carry on then. Thank you.
Because this is major to landowners like myself, that it will be brushed under the carpet. 10, biosecurity risks. Over the last several years, our native plants have had to face many viruses such as the kauri dieback and myrtle rust. Again, on using the current walkways through our reserves, I do not see any biosecurity measures undertaken by WDC with regard to these viruses, dogs or anything. 11, no incentives for landowners. I have provided you with a large list of negatives and probably not an exhaustive one. I cannot list any pros as a landowner in letting the public roam over their land. In fact, the report on the findings of the review of the Walking Access 2008 states providing compensation or assisting landowners with costs incurred as a result of access could not be done without within the Commission's current funding. 12, effective enforcement mechanisms on users. We are continually seeing in the news about the lax or completely ineffective enforcement mechanisms that local government or government has provided to them. If there is any theft, liability, security, safety, biosecurity, infrastructure, health or privacy problems, how can any landowner be positive that they would be financially and justifiably compensated? In summary, we feel that WDC has not initiated any positive consultation with us as landowners other than notification of the proposed walkway, cycleway, bridleway. In fact, WDC have completely ignored and disregarded many major acts of Parliament that have been put in place to protect both local authorities and private landowners. In my opinion, and I'm sure of anyone else in our position, this is completely abhorrent, reckless, irresponsible and illegal. As such, and with regard to all the above points as I've mentioned above, we do not believe that the placement of a walkway, bridleway, cycleway can be upheld, and we look forward to the deletion of such designation from our property. Thank you.
Thank you, Ms. Hanrahan. I think that's pretty clear, but let's see if there's any questions. Ms. Gibb?
Yes, thank you. Yes, Ms. Hanrahan, very full, and I applaud you for your homework. I've just got one question. So just to confirm, there's nobody from the Waikato District Council who has ground truth to this. So they've not actually been on your property.
About 2 months ago, Sarah Chibnall and an expert, I'm sorry, I can't remember his name, they asked to come, and there wasn't a proper meeting arranged. They just turned up one day. Luckily, I was at home and I showed them around the gully, yes. But
thank you. And are you aware that the S42A report writer has recommended to us to delete that designation?
No, I was not aware of that. That is great news.
That's his recommendation to us. So thank you. No more questions.
Thank you, Ms. Gibb. Mr. Fulton?
Yeah, thank you. You're in the country living zone, Tamahiri country living zone, and I understand there's a targeted rate for cycling and bridle tracks and so on, isn't there, that you pay towards every year? A targeted rate for this purpose? Are you not aware of that? No, okay. Just to focus on where you are telling us that this proposed walkway is, it's in the gully, not in your over your higher land property. Is that correct?
Correct.
It is. So there's an Esplanade Reserve in the gully?
No, none at all. As far as we're concerned, we've always thought our land went right down to the stream.
Do you know that as a fact, or are you assuming that that's where it was?
Well, that's what it appears on our title.
But you haven't got the planning maps to actually define your boundaries.
Well, the certificate of title, I would have.
Yeah, that's it. Yes, but do you know where your boundary marks are? That's what I'm getting at.
It has never been properly surveyed, that gully, is from my understanding. So on the certificate of title, the stream is our northern boundary.
Okay. There's been a walking and cycling strategy for the country living zone in Tamahiri for a long time, and this has been proposed, all these connections over many years, haven't they? And they did some public consultation on that some time ago. You were saying you weren't aware of that.
Only generally, never. I've never heard of them targeting our gully or our land. No one has ever approached us about that. The designation on our property was the first time I have ever heard of it actually on our land.
So
that they've been trying to create cycleways, yes.
Okay, can I just get this clear that I've got it right in my mind? It's the gully under the Allan Bridge, which continues on. Some work has already been done down there, hasn't it?
Correct. Yeah, some work has been done there where people have subdivided and have already that provision where you have to give your land along the gully, and that's where they have done the work so far, where people have subdivided and then had to give that bottom land to the council.
So the consequences of not or taking off the designation partial property for this would then actually stop the whole trail, wouldn't it? Because you can't have a trail with gaps in it.
You cannot have
you could only go and stop and start, which you cannot have a continuous walk.
Continue, correct, yes. There is the other side of the gully. I don't know why. It's interesting to note that it crosses over onto our property across the stream to avoid the owner's land on the other side of the gully. I don't understand why it is to cross over onto our land.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Ms. Te Aho?
I was just wondering if you have looked at the vision and strategy document for the river and its tributaries and looked at, the balancing act that councils have to try and provide for in terms of providing access for people to, to engage with the waterways in the district.
I'm not familiar with that document, but yes, I do understand that they're a great thing, but why is it to the detriment of the particular landowners that own that land? There's been no consultation. Why? It's just so rude and unfair. You can't just take things from people. All right, it's for the better good, and I understand that, and they're great, but there's been no infrastructure on the walkways that have already been set up. So how am I to think that my privacy and my security and the land that we purchased at a premium because it had the beautiful gully is just taken from us? That there's been no thought about that.
Thank you. I completely understand your point of view, and thank you very much for your submission.
Thanks, Ms. Tiaho. Mr. Cooney?
I'll direct this question to Mr. Mackey for clarification if he can. Can you just explain to us, Mr. Mackey, whether compensation is payable for the land taken for a walkway?
If the council wants to acquire the walkway or land for the walkway, or get an easement over the land for a walkway, then it would have to provide compensation. It would have to be by agreement. However, apart from the highest priority walkways within the strategy, there's no commitment to any funding to acquire them ahead of subdivision. At subdivision, the Esplanade Reserve comes to the council. There's no compensation for that Esplanade Reserve, and it relates to the banks of a stream or a river. So it's
that's if it's under 20 metres, though, isn't it? No compensation.
The 20 metres is taken without compensation. That's correct.
Yeah. Okay. So thanks. And that Ms. Hanrahan, it's a question of whether compensation is payable. It's not as though it's been taken without compensation in many cases.
Can I just summarise what I understand the situation to be, Mr. Mackey, just following on from what Mr. Cooney has said, is that there's several building blocks in relation to that proposed walkway. The first one is that the district plan signals an intent of the council's wish to create a walkway along the Mangaharakiki stream, etc. And it's shown on the planning maps as something that they would wish to be able to do. The planning provisions say that doing certain things on a walkway such as that are permitted activities, e.g. they can be built without the need for resource consent. But, and I think this is the important part, is that none of that can happen unless one of two things happens. Firstly, the council acquires the land in some form or other, either by purchasing it or by seeking an easement or those sorts of things, or by taking a 20-metre strip when the land is subdivided. There's no ability for the council to come along with a bulldozer tomorrow and say we're building the walkway shown on the planning map along the boundary of Ms. Hanrahan's property. Is that broadly speaking the situation that applies?
That's exactly correct. The only other branch would be for the higher priority ones for the council to use designation powers to acquire the land in that way, but that's not proposed for anything at present.
But even under a designation proposal, they can't just acquire the land for nothing. There has to be a negotiation process or a compensation mechanism under the Public Works Act if they were to do that.
Yes, that's correct.
Okay, that's probably somewhat cold comfort in many respects, Ms. Hanrahan, but if your concern is that a walkway could appear on your back doorstep tomorrow and you'd never know anything about it, that's not the case. The council would have to acquire an interest in that land somehow, and that would need negotiation with you, or it would be triggered by you seeking to subdivide your property to create additional sections, in which case the council is able to take that 20-metre strip. And I would say that's reasonably common around the country to protect stream margins. I mean, I live in Orewa, and there's a coastal walkway that runs all the way along that beach, because that provides public access and so forth. But your immediate concern about the council turning up tomorrow with a bulldozer, hopefully that puts you somewhat at ease, notwithstanding everything else that you've said.
As I say, it's yes, but there isn't 20 metres at the bottom of the gully in most places.
No, I understand the merits argument that you're saying, but if the fundamental concern, as I heard it anyway, was that you were saying that the council could acquire your land and do stuff on your land without any consultation or your knowledge. And short answer is they can't do that part of it. That's notwithstanding whether there should or shouldn't be a walkway in that location, but they can't do the things that you're fundamentally concerned about them doing without you being aware of it.
Yes, but as I say, security and people's safety is so important, and they're not taking care of that with walkways and cycleways that are already in place.
No, and I understand that. You've made that point very clear to us. Thank you. So thank you very much for your submission, Ms. Hanrahan.
Thank you.
What I think we'll do, we are a little bit behind schedule, but we're not bothered by that in the least, but we've been going for a little while. What we'll do is take a 15-minute break for morning tea. What we would ask people to do, if people wish to leave, they're more than welcome to, but if they're planning to stay, we would just ask if you turn your video off and your microphone off. That way you don't have to re-log on and run the risk of not being able to get back in. So we'll adjourn for 15 minutes so that we can kick off. All right, thank you everybody. We'll resume and we'll hear from you now. Thank you, Mr. Dromgoole.
Thank you for that. Look, my submissions are just verbal from notes here. They are factual, and I think you'll find they're not waffle, and should only take me 10 minutes or so.
Very good, thank you.
Firstly, I would like to express my disappointment at this not being a live meeting. I felt its importance it should have been, and it follows from personally being unable to get various meetings with council staff over a period of time. But be that as may, I am seeking through this submission the ability to have an approved wastewater treatment system as a controlled activity within the district plan for Tuakau, and not totally excluded as is proposed. I'd like to background the different wastewater systems available, and the one I favour is as an example for workability. Then, if I may, a little bit of background on Tuakau and where this fits into the past and proposed planning. So the different types of septic tank available, there are many and varying complexity. There is a conventional system, multi-chamber system, aerobic treatment system, drip distribution, sand filter, evapotranspirational and mound system. And another one I found called the Advanced Enviro Septic. That's the one I favour, and the one I'll elaborate on a little bit more shortly. The conventional septic tanks have worked well over the country and in many areas. A lot of residents in Tuakau use the system. Where it generally fails is when it's not put in properly, with insufficient drainage material or too small a field drain. Other systems of varying complexity are fine when they're working well, but they can fail when some of the componentry fails, i.e. pumps, electronic controls, that type of thing. The system I favour is called the AES, the Advanced Enviro Septic System. Used and developed in the United States, used extensively in Australia, and lately New Zealand. Used by the Department of Conservation. So it must have had Eugene Sage's tick. And some of the features: 20-year warranty, no servicing costs, no power, no chemicals or pumps. Complies with the Australian standard and the New Zealand standard 1546.3 on-site wastewater treatment standard. And so when I went to the distributors and manufacturers in Nelson and asked about the application of this in the Tuakau land, the first question was, what's the soil like? So from that, I go to our recently compiled soil test from Engineers Tilsley. It was a geotech report for some land that we own in Coolen Place, Tuakau. And I'll quote a paragraph from that. It says, Coolen Place soil type, residual soils typically comprising stiff to very stiff clay silt to silty clay with traces of sand. This soil type would suggest good soakage. So that's the end of the quote from their report. And so when I put that to AES, they said, yeah, that would be the ideal soil type for the situation and application of their equipment. So I asked, what would the size of the field footprint be required? And they said for a 4-bedroom dwelling, a 54 square metre footprint soakage area. And this, with their system, can go under a concrete driveway. So if you relate that to the current and proposed footprint plans for Tuakau, under the current footprint is 20%. So on the quarter-acre sections that we own, 20% is house, so that leaves 800 square metres, 54 square metres for this septic tank. That would work easily. Under the proposed plan, 40% footprint would leave 600. Again, under 10% of that available land would service this system. So I would ask on that basis that it should be a considered option. And I would also ask, environmentally, is it not logical and sustainable to consider and have the choice of an on-site waste disposal system, as opposed to all houses going into a common sewage pond, which has been the way of for many decades now? And I would question that, and I wonder whether the Greens sit on this policy, because if the soil can take it, if the advancement of technology is such that it can be done, as in my submission, I believe it should be allowable. So that's basically the system, and that's what I want to leave that on there, please. But to further see how this fits into Tuakau, I would just consider a couple of points. I wonder whether part of this is not the $10,600 odd that is the connection fee that council take if you connect to the existing system. Because some of the land that my family and I own is adjacent and can go on to the current septic, the current sewage system, but we still can't build on those titles because of an old bylaw. And there have been inconsistencies in the council's application of the district plan, such as with the early Pocono developments, where sewage was allowed to be stored in tanks and trucked away. So to the background of Tuakau, I would, with respect, ask the panel to take some time and have a topographical look at the town. What you'll see is Tuakau College, built in 1974. I was a foundation pupil there, and it's way to the west of the town. I could look out of windows at that school in 74 and look at Market Gardens. You can do exactly the same today, because there has been virtually no development in that part of town. Tuakau Borough Council, which changed its governance to Franklin District Council. During that period of time, all the focus was on Pukekohe. Tuakau went backwards. Went from a town with 4 banks, 2 stock and station agents. They all left. When the governance changed to the Waikato District Council, the focus has been and has been since on Pocono. And the stellar growth and expansion in Pocono should in part have been some of which in Tuakau, and it has not happened. So in concluding this, really, I would say that that plan of the town, the school in 74 should have been the catalyst for growth around that school, and it hasn't been. There are titled sections, many of which, separate titles, rated separately, can't be built on because the council still adheres to a 45-year-old bylaw. It is ridiculous. And I see this septic tank rule as just another way of of basically making it harder for current owners like myself to develop this land. But in final conclusion is what I believe is there has been incredible advancements with technology with septic tanks. They will work and it should not be excluded from this plan. Thank you.
Thank you very much, Mr. Drongle. I think that's pretty clear. Let's just see if there's any questions. So, Mr. Cooney.
I see wastewater servicing for new development or subdivision as a permitted activity under P3 of 1411, and it includes is provided with a site-contained alternative method of waste disposal that complies with an Australian and New Zealand standard. What's your comment on that?
Are you reading from a different area that I was? Because the one that I was reading excluded it from those sections.
Okay. Right. Well, we'll clarify that.
That's why I was asking for a controlled activity, because under the wording I read it was fully excluded.
We'll check that out. Thank you.
I think the distinction relates to permitted activities versus subdivision. I think there's a distinction between subdividing and then the installation of infrastructure for an existing lot with an existing title and so forth. I think that's the distinction.
Yes, probably that's the application, sir, because these are existing titles.
Yeah, okay, understood. All right, thank you. Ms. Gibb?
Yes, thank you. Thank you, Mr. Drongle. I do understand there are many advances in these systems, so I appreciate that. Can you just remind me again the size of the sections you're talking about?
They're the traditional quarter acre, so 1,011 square metres.
Okay. Somewhere in the back of my mind, and I may be wrong, I'd heard that we needed a minimum of 2,500 to permit alternative things, but I'd need to look into that. But I appreciate your submission. Thank you.
Yeah, that's possibly right in your rural residential zoning.
Yes.
But again, that's been in place for many decades, and the advancement in this technology has leapt forward. You know.
Yes. Yes, and I have heard of many new ways of doing these things. So yes, we'll take that under consideration. Thank you.
Thank you.
Thank you. Ms. Tiaho?
I don't have any questions. I just want to say that I understand your submission and thank you very much for taking the time to present it.
Thank you.
Mr. Fulton?
I suppose my question is, why wouldn't you want to connect? Why would you want to put in an alternative system?
Well, my question, sir, is you should have the choice, depending on where the section is.
Okay.
Why is that not? Not all sections can currently go onto it, and some would be better served by septic tanks.
So the quarter acre sections which you've got are not intended to be subdivided. You intend to keep them at that size. You'd have to, wouldn't you?
No, you wouldn't have to. But that subdivision is a different option. What I'm expressing now is the right under the proposed rules to have the ability to have a septic tank on that quarter acre.
Okay, thank you. Understood.
I don't have a question, Mr. Drongle, but what I will ask Mr. Mackey to do is that when he does his reply tomorrow, if he could just explain the factual planning situation in terms of what the plan does and doesn't allow in relation to the matter that Mr. Drongle has raised, just so that we're absolutely crystal clear on what the plan is and isn't saying at the moment, and then we're able to consider that submission against that starting point of view.
Just
so
if I may then, sir, these sections are treated quite differently in the existing plan, and there's a special clause for them.
No, and I think we understand that, but we just want to get that recorded for our future process so that we can consider that background against what's being proposed at the moment and what you've said.
Okay. Yep, thank you.
So final point, I note that your surname looks like a very famous horse racing family name. Are you connected with the racing game at all?
Yes, distant relation, he is, yeah.
Okay, very good. Anyway, thank you very much for your submission, Mr. Drongle. And as I say, Mr. Mackie will be able to clarify the planning situation forensically for us tomorrow, and then we can consider that, what you've said in light of that, and what we may be able to do about it. So thank you for your submission.
Thank you very much.
Mr. Greenie, please.
Yes, good morning, Mr. Chair and Commissioners. Mr. Chair, is it possible if I share a screen just to step through a presentation that I had?
Yes, you can.
Earlier?
Yes, we'll just need.
You have access to it now.
Should be ready to go.
Oh, okay. You're sharing it, or I'm sharing it?
No, you're sharing it.
Okay, thank you. Yeah.
Well, is that what you want to do? If you're happy to share it, that's probably the easiest.
Can you see that now?
No.
Okay, I'll just try once again. Share screen. Right, sharing screen now. Worked this morning.
It's not working at the moment. Has Mr. Bell got a copy of that? Because he can.
Yeah, I can bring it up on my
screen. Let's Mr. Bell share it from his end, Mr. Greenie, and then you can tell him to flick pages as we need.
Okay, thank you very much.
How does that sound?
Yeah, that's wonderful. Thank you.
Good. There we go.
Great. Okay. So look, speaking on behalf of myself and my neighbour and 20 others, basically a submission to remove the Redwood Grove indicative road. And it's a subdivision. It's a submission that's supported by the Tamahiri Community Committee. And from what I can see, directionally at least, from the Section 42A report. The submission is opposed by two other submitters, Mr. Chantal Berry and Mr. Mong Un Yao, and perhaps I could just speak more to that shortly and explain, I think, their position. So if I can take all of the submissions that we've made as read, including...
Yes, please. We have read those, Mr. Greenie, so we're broadly familiar with what it is you're seeking and why, so that's fine.
Fantastic. Yeah, and Mr. Chair, is that including the McCracken Surveys report as well as the CKL report?
Yes, it is, but if you want to highlight anything in relation to those, then you should feel free to do that.
Okay, no, thank you. Look, I'll just take them as read. So look, really what I want to do here is just make a few summary points really, and then just be in a position to take some questions.
Very good, thank you.
Yeah. Mr. Bell, please. Excellent. So this is the operative district plan that's currently in place, and there's two arrows. There's a little red arrow that's pointing to the Redwood Grove indicative road. Thank you. And there is also a green arrow which points to the Elmwood Lane indicative road. And the key point here really is that Redwood Grove is intent important, location unimportant, and Elmwood Lane indicative road is location important, and was always intended to be the access to the Elmwood Lane facing properties of 286A, B and C. Mr. Bell, please. Thank you. So in the notified district plan, which of course is the one that we're discussing at the moment, both indicative roads have been retained, but you can see where the red arrow is there that the Redwood Grove indicative road has been extended into 286A. I assume with the intention that it be extended further to access 286B and C if they're to be further developed. Elmwood Lane indicative road, of course, is still in place and runs adjacent and currently services each of those three undeveloped lots, 286A, B and C.
Mm-hmm.
Please. So simplistically, we're seeking Redwood Grove indicative road to be removed because its original purpose, which was to access 264 Newell Road, has been achieved by another means. What I mean by that is 264 Newell Road, the three 264 properties, once it was subdivided, are all accessed off Newell Road itself. So there is no need for that road to access those properties any longer. So that's why we say it's been achieved by another means. And similarly, there's no practical need to retain or extend the Redwood Grove Indicative Road to access the undeveloped lots that are already serviced by Elmwood Lane. So I guess the other part here is this has been going on for quite a while now. And so we're seeking to provide certainty to all landowners. And they're the landowners that whose properties run adjacent to the Redwood Grove Indicative Road, but also the owners of the properties that are currently accessed off Elmwood Lane, some of which would like to be in a position to further develop their properties in the future. Please. So you can see here, I hope you can see on your screens.
Mr. Bill, can you just try and make that, yeah, that's better. Thank you.
Yeah, good. So the red line, oh, that's good. Yep, the red line shows the extension of the Redwood Grove Indicative Road, with the dotted red line showing how it would be potentially extended into those other blocks to access them in the event they're further subdivided. But the green Elmwood Lane line is the road that already exists and already services those 3 undeveloped properties. And of course, potentially a further undeveloped block right at the end of that road. And so we think it is a very logical and more cost-effective solution to access those undeveloped roads off Redwood Grove, off Elmwood Lane. And I've got here that offers greater development optionality and utility. And what I really mean by that is there will be more sections available in each of those 3 undeveloped lots if they're accessed off Elmwood Lane. But also the owners of those properties will be able to develop those properties progressively or when it suits them and not be reliant on each other for access through the first 2 properties to reach the 3rd undeveloped property. There's also the additional utility of being able to access a further block of land at the end of the Elmwood Lane Indicative Road. The idea of developing Elmwood Lane, vesting it as a public road, is obviously well supported by those who have joined in this submission, as well as the Tamahere Community Committee. But just speaking now to Mr. Chantel Berry and Mr. Mong Eun Yao, who have opposed the submission, they are broadly supportive of using Elmwood Lane to access their properties for the utility and the logic that that presents. But of course, they can't openly support that until it's confirmed that they will have access to their property if Redwood Grove Indicative Road is removed. So that is the primary reason that they have opposed the removal of Redwood Grove. It's simply because they're seeking to, I guess, guarantee the ability to develop their properties further in the future. And so if Elmwood Lane was to be confirmed as a public road, or the road that would be used to access those properties if they were further developed, they would be supportive of removing the Redwood Grove Indicative Road. With my neighbour, Robert Alexander, we engaged CKL, a survey firm, as I'm sure you're aware, to do basically a traffic assessment or transport assessment of Elmwood Lane, which, as you know, having read it, is supportive of Elmwood Lane being the access of choice to those 3 properties, certainly being viable. And I make the point there that it supports the transport objectives of the proposed district plan. So look, really all I want to say now is that, I think we've made a solid case for removal through, I guess, a comprehensive submission to the draft, the notified plan as well. Elmwood Lane was intended to be the primary access to those Elmwood facing properties, or Elmwood Lane facing properties that are currently accessed off Elmwood Lane. And through the CKL report, it is clearly shown it is viable. So nothing else to add, Mr. Chair, but very happy to take some questions.
Thank you, Mr. Grenny. Mr. Yahoo?
No, I don't have any questions. It's very clear. Thank you very much.
Mr. Fulton?
Yeah, just a question on Elmwood Lane. Is it of a suitable standard at the moment to take the additional traffic? Just from my observations, it was built as a lane, not as a road. Does that have to be upgraded?
Yes, it does have to be upgraded, Mr. Fulton. I guess the benefit is that it is already a road, whereas the other option isn't. And that really was the purpose of the CKL transport assessment, to determine that that was in fact reasonable and viable. And that report confirmed, the work they did confirmed that it was.
So the cost of the upgrading would be met by the affected people. Is that how it would be worked?
That is my understanding. In a similar way that accessing those 3 undeveloped lots through a Redwood Grove indicative road would also have to be funded by that group, but would be more expensive and would mean that there would probably be less sections available for development. So the development contribution would be less as well.
Thank you very much. Thank you.
Ms. Gibb?
Well, no, thank you, Mr. Greeny, for your presentation, and it's very clear. I have no questions.
Thank you, Ms. Gibb. Mr. Cooney?
Yes, thank you for that. That's you've been very clear in the way you presented it, and we appreciate that. Your main concern is the road impact and that the amenity values if this road was used. Is that your principal concern?
My main concern really is that the primary purpose of the Redwood Indicative Grove, the Redwood Grove Indicative Road has been fulfilled by, I guess, the Newell Road properties being accessed off Newell Road. There is, and also, I guess, the Redwood Grove number 37 properties also actually now being developed and having its own access off Redwood Grove. So there's no purpose for that road anymore. Its intent, original intent, has been satisfied. If the Redwood Grove Indicative Road was to go ahead, it has quite an impact on the properties that are adjacent to it, of which there are at least 6, and whom frankly I think will have purchased their properties and developed those properties on the understanding that the indicative road would be removed, given that its purpose to access the Newell Road properties especially had been satisfied by those properties accessing directly off Newell Road. That was certainly the case for us. But also from a development point of view, and almost taking the bird's eye view or the drone view, it is so logical that those 3 properties be accessed off Elmwood Lane, that they're currently accessed off and where a road already exists. It just needs to be widened. And I guess the purpose of the CKL assessment was to determine that that was in fact something that was viable, and it is.
Yeah, okay. Thanks very much for that.
Thank you.
Mr. Greeny, Mr. Mackey has spent some time in his Section 42A report addressing your particular submission. And
yes,
it seems to me that, and I'm at paragraph 131 of his appendix, which has got the heading D12A, and I just want to read a little bit of that to you and tell me if this is your understanding as to whether it's correct. But he says, and I'm not going to read it all sequentially, I'll just read the relevant bits that ask the question. He says, I could support the removal of the indicative road off Redwood Grove if the matter can be resolved by council accepting vesting of Elmwood Lane as public road with all properties enabled access. Advice from council roading engineers is that Elmwood Road is not yet designed to public road standards. Therefore, access to this road for future properties in the area is not yet secured. I note that there appears to be substantial additional subdivision potential down Elmwood Lane all the way through to the river. This is, I think, the important part. The owners of properties accessed via Elmwood Lane own individual rights of way easements to access their properties. and those easements would need to be acquired or surrendered to create a public road. So it just seems on the, well, it just seems on the face of it that there's a general acceptance that what you say makes sense. It's just that the ability of the council to do what you're proposing in green depends on altering some existing property rights so that that road can be vested in council. Is that your understanding?
Yeah, Mr. Chair, there is a whole backstory on this stuff that I guess doesn't always read in favour of the council, but I've chosen not to go there, but more just to be forward-looking and try and focus on what is logical here. There has been a number of discussions by our local councillor with the owners of the 3 undeveloped properties around, yes, I guess, the potential to I guess, further develop the Elmwood Lane as a public road. And my understanding is that they're prepared to give up a small part of their respective properties, I guess a boundary, to make the road wider. And that would have a high level of utility for them than seeking to develop their properties through access, yes, through Redwood Grove, because they could do it in their own time and they can do it more economically and actually get more sections. So
yeah, no, I understand the logic of what you're saying. Can you just explain to me your understanding, showing where the green line is on Elmwood, showing Elmwood Lane? You've shown the 3 properties you're referring to are the 3 dotted little offtakes to the left. Do those do the properties to the right of the green line, do they have legal access to Elmwood Lane, or is it only those on the left-hand side of your picture?
I understand that, well, certainly the properties on the non-dotted line side are all, yes, accessed off Rivington Lane.
Okay.
But there's a whole backstory here about each of those properties having a slither, if you like, of Elmwood Lane that I understand may have been an oversight or should have been removed.
Yeah, and I think, yeah, and I think that's the problem that the Section 42A report says, is that it's one thing to vest a road as public road, but if there are private interests in it, they need to first be extinguished or addressed in order for that to happen. Because it's a little bit like what Ms. Hanrahan was saying earlier. You know, if someone owns something, you can't just commandeer it and start, you know, doing what makes sense if you haven't got legal access to it. So yes, yeah, I guess all we can do is take that on board and have a very good think about it. And perhaps if Mr. Mackey, when he replies tomorrow, if there's anything additional to what he said in the passage that I've read out that would help us, we'd appreciate hearing that as well. I think just in terms of not necessarily his opinion on what's right and wrong, but just simply on the legal situation so that we can be very clear on that.
Yeah, thank you, Mr. Chair. I think my understanding is as well, the council roading engineers have actually done some quite good work on this and are reasonably well progressed, but they've simply run out of time yes, prior to this hearing to be able to conclude their works. And so, and I know in Section 42A
yes,
report there that there is potentially a request to seek some further time before a final decision is made. But
I mean, one of the things, I mean, leaving. Sorry.
No, sorry, after you.
I was just going to say, we need to think about the merits of this, but I suspect that there may be a way of addressing this if we were minded to agree with your submission. And the reason that I can't say one way or the other is that we haven't considered the merits of what you've said yet. So it would be improper of us to say one thing or the other. But if we were attracted to your proposition, it may be that it would be possible to assume provisions that says the indicative road only exists until such time as Elmwood Lane were made a public road or something or other. Because the problem that you and your neighbours would face. Go on.
Yeah, I think you know, just looking at it logically and plainly, and you know, almost from a bird's eye view, it would seem a suboptimal outcome as per our submission if that land was ultimately accessed through somewhat convoluted use of.
I think we understand that point, but you couldn't, conversely, you couldn't create subdivision on the land that you're talking about if they can't get legal access down Elmwood Lane because of existing property rights, and they would have to be addressed irrespective of the logic of what you're saying. And I think that's the problem that we've got to grapple with.
Yeah, understand.
Okay, but that's very helpful.
Mr. Chairman, I take it from all that the actual Elmwood Lane is a private lane. That's what
Mr. Mackey has said in his report.
Yeah.
Yes.
Yeah, and that's the problem. Yeah.
And that's the problem at the moment. That's got to be solved before any practical problems can be resolved, it seems to me.
Okay.
But that's very clear, Mr. Greeny. You've given us something to think about, and we'll hear from Mr. Mackey tomorrow again, just in terms of him clarifying what the legal situation is, and then we can grapple with the merits argument of what you've proposed. So thank you very much for a very comprehensive submission.
Great. Thank you, Mr. Chair. Thank you, Commissioners.
Thank you.
I'll sign off now. Yeah.
Thank you. Which brings us to Mr. Ongley, who I saw briefly. There he is. I've seen him again. He just moved around on my screen. I don't know, Mr. Ongley, were you here at the start of today when we went through some background information and so forth?
A little bit of it, yeah.
All right. Well, I won't reiterate that, but you're going to tell us about the cycleway at Raglan. So,
yeah,
as I said, we have read your submission, so you don't need to read that out. You just tell us the nature of the problem and what you want us to do about it.
Yep. No, it's not going to be overly complicated. Basically, in principle, the idea of a walkway cycleway is a great idea. However, the practicalities of where it's been placed between Lorenzen Bay and Cox Bay is going up onto a cliff, so it walks along maybe at sea level and then jumps up maybe 15 meters along a cliff, which then drops back down. I just think that that particular cliff, which is at the bottom of my property, is actually at risk of subsidence and rockfall. So therefore, I don't think it's actually suitable there. Potentially, the better path for it is down the bottom, but further out, so that if there is a rockfall or subsidence, that the path doesn't get taken out at the time. And that's all.
Well, that was short and sweet, and I think we understand the problem. We actually were in Raglan between lockdowns, having a look around, and we certainly had a look at Bayview Road. We are broadly familiar with. We're not familiar with your property per se, but we're familiar with the area that you're talking about. So I think we understand the nature of the submission that you've made and what you want us to do. But let's just see if there's any questions around that. Ms. Gibb?
No questions. It's very clear. Thank you, Mr. Ongley.
Mr. Fulton.
Just a question, Mr. Ongley. Do you see there being an engineering problem with having it along the top of the cliff? I know your preference is probably to have it below, but is there any reason why it can't be engineered along the top? You're saying it might subside, but how that we don't know that, you don't know that as a fact. Perhaps you didn't hear that.
He's frozen.
I think he's dropped out.
No, he's back. So, did you hear that question, Mr. Ongley? Are you there, Mr. Ongley?
No, sorry, it dropped out.
All right, Mr. Fulton, would you mind just repeating that question, please?
You're back on. Okay, my question was saying, is there any engineering reason why it couldn't go along the top of the cliff? Your preference is for it to go below. but you don't know any facts that there'd be an engineering reason why it couldn't be put along the top.
The rock is unstable. We've actually, through the same process, we've got a, I think there's going to be some new restriction on building capabilities on the bottom of those sections because of the unsuitability of the rock around there.
Okay. Thank you.
Mr. Yahoo?
Nothing from me. Thank you very much.
Mr. Kearney?
Oh, yes. Mr. Ongley, who owns the land down the bottom?
It just goes into the ocean.
Okay. But the ownership is, you said to put it down lower.
It would be, you would have to follow along the coastline.
Okay. And that's public land, is it?
Correct.
And is that subject to erosion as well and that type of thing?
You'd need to put piles in, so you'll have environmental issues. You'd have it'd almost be like a wharf of sorts sitting out of the water on the high tide. But that's probably the only practical way of doing it if you're wanting a walkway.
So that's pretty difficult to do, isn't it? Wouldn't it be Mr. Fulton's option to look at the engineering feasibility of where this is located? You've said you're not opposed to a walkway, you're just raising it by way of a risk here.
I think if you had a good site visit, you'd
okay.
soon understand the unsuitability of the rock on that cliff.
Yeah.
For example, my neighbour's land just recently subsided. So yeah.
Oh, I don't think we can take.
So
any
my recommendation would be to, my recommendation is to have someone come on site and actually look at the rock itself and so forth.
I suppose the point I'm getting to is if you say it shouldn't be on the top and it's pretty difficult down the bottom, where would it go if we wanted to promote the walkway?
I'm not sure if you've been down to New Plymouth, but they have a walkway going along their coastline, which is really amazing for their community. And I would try and base it along their sort of model, what they've done.
Okay.
Yeah.
All right. Thanks. Thank you.
Thanks, Mr. Ongley. I don't have any questions. Thank you. Thank you for your submission. It's pretty clear. Thank you.
Cool. Thank you.
Which brings us to Mr. Shaw and Ms. Addy from the surveying company, please.
Yes, good morning, Chair and panel. My name is Lee Shaw, Planning Manager at the surveying company. Vanessa has put in her apologies. She has to attend a family matter today, unfortunately.
That's fine, thank you.
In relation to table 14.12.5.1, which is separation distances, our concern there is that the objective of local roads is to maximise property access, and we'd like to see that separation distance between accesses, which is shown in column N, being deleted from that table 14.12.5.1. In relation to 14.12.5.3 for minimum site distances, we're concerned that we have 3 documents which outline site distance requirements. We have the proposed district plan, we've got the regional infrastructure technical specifications and the NZTA's guidelines for visibilities at driveways. We'd also like to see that table 14.12.5.3 deleted from the district plan and reference made to the relevant engineering code of practice, which is the regional infrastructure technical specifications currently, but may change in the future. I'm going to jump to access and road conditions for rural and country living zones, which is table 14.12.5.15. Again, I'm just going to shorten it to the RITS, is Council's current engineering code of practice. and we think it's inappropriate that formation standards be included in the district plan. We'd like to see the deletion of seal widths and berms from table 14.12.5.15 for all rural activities, and refer instead to the relevant engineering code of practice for transportation standards relating to the design of roads. And popping back to table 14.12.5.14, which is access and road conditions for urban environments. As I stated previously, for rural environments, we'd like to see the deletion of seal widths, berms, and in this case, the curb and channel / water table columns from that table for urban activities. Again, referring to the code of practice instead. Additionally, we're concerned the proposed minimum road right-of-way reserve widths are going to restrict and limit future urban subdivision proposals, and that the way it's currently written in the district plan is an inefficient use of the urban land resource. So we would like those minimum road reserve and right-of-way reserve widths reduced as follows for residential and village zones. 3 meters for a single user, 4 meters for 2.2 to 5 users, 8 meters for 6 to 10 users, and 10 meters for 11 to 20 users. We feel this would provide more flexibility for subdivisions and also reduce council's maintenance costs on unnecessary public roads that service a small number of dwellings. That was all. I just wanted to thank you for your time and invite any questions on any of those matters.
Thanks, Mr. Shaw. Let's see if there are any questions. Ms. Tiaho?
Is it fair to is the real the main driver for your submissions around flexibility, or is it around cost?
No, it's around the use of the urban land resource. It's the proposal to have 8 meters legal width for 2 to 4 users and 5 meters formed width for 2 to 4 users is crazy. That's, you know, that width can service so many more households. If you're just doing a 2-user subdivision, why would you have such excessive use of land?
Okay, thank you.
Thank you. Ms. Gibb?
Yes, thank you. If I understand you right, it would be reducing the access on the right-of-ways. That in that particular comment you made.
Yep.
Have you considered emergency vehicles and the fact that they would need to be able to get access to properties in severe situations?
Yes, and that's currently something that is considered under the Franklin rules. I know the emergency services are wanting the 4 meter width, which we have proposed for more than 2 users at minimum width. Length is also something to be considered. So if it was a longer right of way, there needs to be a turning area at the back for emergency services. That could be written into the district plan. If it's only a 30-40 metre long right of way, well, realistically, emergency services are going to park on the street and run the fire hose up the driveway. They don't need to park at the front door.
Yeah, okay, thank you.
Thanks, Ms. Gibb. Mr. Fulton?
Yeah, no, I don't have questions. Thank you.
Mr. Cooney?
No, thank you.
Just one question from me, Mr. Shaw. How would you suggest we deal with the fact that the RITS guidelines or standards are subject to change and so forth? How would we make sure that the district plan kept current with the latest version of that, do you think?
Well, that's exactly why I encourage that the district plan don't specify the standards. The RITS is the standards. They are flexible. If something's not working, they will be reviewed, they will be changed. I think we have had instances where it's duplicating where you've got to assess the 3 different documents to try and get the resource consent approved.
Yes.
If the RITS isn't working, it's a Waikato-wide document. It will be reviewed.
I'm guessing, I'm trying to think ahead and say, let's say they got thrown in the bin because they didn't serve their purpose anymore and a whole new regime was contemplated. And maybe that's fanciful on my part. I'm just mindful of the fact that if you refer to something that ends up not existing, you're sort of left with a bit of a vacuum, as it were.
Yeah, it should be generic, as in refer to council's current engineering code of practice. Now that the name of that document may change, but I would imagine there will always be a code of practice.
I'd be keen to get Mr. Mackey's view on that tomorrow, in terms of by referring to a generic document that doesn't yet exist in a standard that may or may not do whatever, just how appropriate that is. I mean, I understand the point that you're making very clearly, Mr. Shaw, don't get me wrong. I'm just wanting to make sure that if we were attracted to your proposition, that we did it in a way that was appropriate and worked properly in terms of both practicalities, which you've addressed, but also legally. So we just want to, it would be helpful, Mr. Mackey, if you could just give us some guidance on that tomorrow, please.
Yes, and I'd also do note that the Franklin section of the district plan has had commentary added to it, which advises that the current engineering code of practice is the RITS. Not sure when that was added, but that is something, they are tweaking the district plan without going through a formal plan change process. They are adding comments like that to it.
No, and understood. We just want to make sure that whatever we do is bulletproof legally. We don't want to provide something that everyone seems to think's a good idea, and then someone says, well, you can't do it because it's ultra vires. So Mr. Mackey can advise us on that tomorrow, please. But thank you very much, Mr. Shaw. That's very helpful.
Thank you.
Our next submitter is Parkmere Farms, Mr. Grayler, if I've pronounced your name properly, Mr. Grayler. I hope I have.
Almost, sir. Grayler.
Grayler.
Yep.
I'll get it right next time.
No worries.
Thank you very much. As I say, we've read your information, so you don't need to read it. You just need to tell us what the problem is and how to address it, please.
Right. Yeah. So what I've done, sir, just to help, is I've done a summary of my summary, if that's helpful. So
yeah, I'm sure. Well, that's excellent. Thank you.
Perfect. Okay. So thanks for your time. I remain unsupportive of including the noise-sensitive overlay provisions. So the noise-sensitive overlay provisions is just a short name I've referred to the proposition of the 100-metre overlay and then applying a rule framework and policy framework to that, because they have still not been subject to the detailed evaluation that is necessary to demonstrate they are the most appropriate way to achieve the purpose of the Act. The Section 42A report provided what can only be described as a high-level Section 32AA assessment of the noise-sensitive overlay, and a more detailed and robust Section 32AA evaluation is required for the panel to make an informed decision on whether the provisions are appropriate. Mr. Wood provided a Section 32A assessment to support his statement, but in my view, this only partially fills the vacuum that existed prior. This is because the assessment is not location specific and has not been tailored to an application within the Waikato district, like I'd expect it to be. The provisions will apply to thousands of properties within the Waikato district without a detailed and robust Section 32 evaluation having been undertaken. These provisions would apply to the properties irrespective of when the rules may be triggered or what condition the state highway may be in. Furthermore, based on the small number of further submissions received on the noise-sensitive overlay provisions, I suspect most of the property owners are completely unaware of the implications of the noise-sensitive overlay provisions. Both Kiwi Rail and Waka Kotahi cite reverse sensitivity as the justification for the rules, but no evidence has yet been provided to demonstrate that reverse sensitivity issues are actually manifesting within the district. I also have some concerns around the clarity and suitability and feasibility of the rules. One example of this is the requirement for alterations to existing dwellings to be designed and constructed with acoustic insulation, regardless of the scale and nature of those alterations, and whether or not that dwelling was actually established prior to the adjoining transport infrastructure. Finally, hearing panels in both Auckland and Whangarei have already rejected similar noise sensitive overlay frameworks in their district plans. This was due to a number of reasons that, in my view, continue to apply to the Waikato district context. These were an absence of rigorous and robust Section 32 analysis, because the overlay would affect a very large number of property owners, and a cost-benefit analysis of the implications and who would bear the cost was not undertaken. There was also equity and fairness concerns, because the overlay would affect thousands of properties, and that obligation should be placed, at least in part, on infrastructure providers to manage their impacts in terms of noise. They also had natural justice concerns based on a concern in relation to the properties that would be affected by the provisions and whether or not they were aware of the possible consequences of the provisions, which may diminish or constrain their right to be heard. So that was a summary. I'm open to take any questions the panel may have.
Thank you, Mr. Growler. That's pretty clear. Let's see if there are any questions. Mr. Fulton.
Yeah, no questions, but thank you very much for your submission, because I think will certainly be interesting to hear from Waka Kotahi and the rail this afternoon, or tomorrow. Thank you.
Thank you. Ms. Gibb?
No questions, but do understand the situation, as we have been involved in the Waikato Expressway coming through our district, and we've had both sides of the stories from landowners and from the agencies. So we, as Mr. Fulton says, it will be interesting to hear from the others this afternoon. Thank you.
Thank you. Ms. Tiaho.
I just do wonder whether, given that you've done the research in those other areas where the 100-metre setback was not followed through with, what was the solution that they went with to protect those, you know, who live in those buildings near these expressways?
So those weren't a setback, in that they were effectively an overlay. So what they've applied, what they've both settled on in those instances is that because there was that lack of evidence, they didn't have any other option but to go away from that. And so there's no specific provisions that apply. So a good example is that I have a client with a large landholding in West Auckland. It's just short of Westgate. You know, many years ago it used to be on the edge of Auckland, but now you would almost call it sort of reasonably central, and in that case the northwestern motorway runs right next to it, and they don't have anything other than a side yard. They've got a metre side yard that they have to meet, but otherwise they put the onus on the developer, and in that case the developer is going to put an acoustic fence up on top of a bund, but that's their decision, and they do that because they think that might help either the sales or that, you know, they make a commercial call. But the district plan's silent on it, doesn't actually apply to it at all.
Thank you. Mr. Cooney.
In your evidence, you've said the properties affected would be 1,698 would be affected by the road noise mitigation and 2,741 for the rail. Where did you get those figures from? So those
are from the submitters. They actually sought that from the GIS team at council. So if you look, I've included a footnote in there that says that was from Waikato District. So I didn't actually personally do that, but the submitters requested that from that service.
So that's where it came from. Okay.
Great.
Yeah. Okay. And I thank you. Thanks for that.
Just one from me, Mr. Growler. You've mentioned, and you would have heard me ask Mr. Mackey about Whangarei and Auckland, where you've said that this proposal was rejected. what's your understanding of how this issue is addressed elsewhere around the country? And is there anywhere where this proposal has been adopted in the way that the other submitters have proposed?
I haven't actually done the done any investigation on that, but the district plans where I've dealt with it, where I've seen it, are those ones in Auckland. I haven't seen a good approach on how that, a clear approach on what works really well. I don't know if there's necessarily a benchmark, but I guess as part of that, you would want to look at some options and then apply it to its Waikato context. I think that's the real thing that's lacking in this, is that Waka Kotahi's done a section 32A, which is pretty generic. It's got some good stuff in there, but it hasn't been applied to a context. So I think you would have to, that's a pretty big exercise in itself to go through and figure out what the best approach is. And I guess that's the whole point of a section 32 assessment, and that you're going to have some rigor to it.
I suppose the point is, you pointed out where it doesn't work, and that's 2 of the 68 or whatever the number is of TAs, which is fair enough. But I mean, the question that I'm asking you is this, I don't know what the exact number is, but if there's 66 others, if this has been adopted in 66 other cases and they haven't been done in these other cases, because that puts a different context on it. And I'm just trying to understand. So, and I'll be asking the Transport Agency and Kiwi Rail this question, obviously.
I'm not
where else, you're not aware of where else this has been adopted?
No, correct. I'm not aware of it being picked up in any other district or region across the country. It's the first instance where I've seen where the council is actually recommending it get adopted.
Okay, all right. Thank you.
That helps.
That's helpful. Yeah, thank you very much. Thanks for your submission. Brings us to Mr. Barrett, please.
Yes, good morning. Can you hear me?
Certainly can. Thank you.
Right, thank you. It's working. Thank you for your time this morning. I'm going to be relatively brief. Our concern submission was over table 14.12.5.14, access and roads. Like the former submitter from the surveying company, Mr. Shaw, we certainly don't agree with the proposed 8-metre width for access allotments. It seems incredibly excessive, and there's some good reasons, in my opinion, sir, why 8 metres needs to be reduced. We did submit that it should be somewhere around about 3 metres for one lot, and some scaled up from there. I'll come back to that in a moment. Having read the section 42A report and went back to the section 32 report, I don't necessarily find any great justification for the 8-metre width. So it's a bit difficult to understand how we got to 8 metres. Also, I recall reading in the council's justification for that is that, yes, the NS 4404 standard has been amended, which is amended by many councils for their own reasons. I think it's very important for you to understand before you make a decision exactly what those reasons are, why it's gone to 8 metres. The council talks about local conditions, which I'm not entirely sure about what's so different about the Waikato is from Hamilton City, Waipa, Hauraki, Manamata, Piaka in terms of its urban areas. Doesn't seem to me to be a great difference, and I work in all of those jurisdictions. The council also did mention the word preference. They have a preference for it. I really don't know what that means, and I think, whose preference are we talking about? So I think there's just some couple of things there that perhaps the panel could seek some further clarification on to justify the 8 metres. Council talks about the need for two-way access down private urban access. Talks about passing bay and the need to run to manage stormwater. And that's all fine and well and good. Council also talks a little bit about amenity, which I find a little bit more disturbing than the other matters. I did a quick review of, not too quick review, a sufficient review of other Waikato region councils, and there's not a single one that would have 8 metres to access private allotments, certainly up to 4 or 6 allotments. So unless other councils have somehow got it wrong, or that the Waikato district appears to be so completely different, there's a big gap, there's a huge gap between what is proposed as to what has been generally acceptable by most councils and probably beyond the Waikato region in that regard. The other councils also scale, depending on the number of allotments, the width, the legal width and the formation width changes. And the district proposed plan has no scaling other than for 1 lot, and then it's the same between 2 and 8 lots. They divvy it out between 2 and 4 and 5 and 8, but there's no change in terms of the 8-metre legal width or the 5-metre carriageway width. So I think there needs to be some thinking about scaling as a real potential to reduce the 8-metre width. Council did talk about passing bays and the need to manage stormwater. These are not, in my experience, 25 years experience in urban areas, they're not significant issues. Passing bays very, very rarely come up and can be handled on, in a case-by-case basis. So they're not the norm. So there is, again, there's no requirement for an 8-metre access way for something that hardly ever happens. We think that the range of access is, that would be sufficient to allow for all those matters, and that includes, I note, emergency services and so forth, and 4 metres is a reasonable width as per the fire service has indicated, and I don't have any issue with that at all. We think that the panel should be seriously looking at 1 lots to be somewhere around about 3 to 3.6 metres legal width, with a sealed width from about 2.5 to 2.8. 2 to 3 lots, we would suggest 4 metres would be a good legal width, with potentially 3 metres sealed. 4 to 6 allotments, you probably need to go to about 5.5 legal width or 6 metres, and about a 4.8 metre seal. And that kind of brings it back into the scenario of most other councils, and obviously the years of experience that everybody has had with urban private ways. They're tried and proven, and again, I do not seem to understand why 8 metres has been proposed. There are some quite significant difficulties when we're looking at in the Waikato with 8 metres in terms of residential infill and also with greenfield development. It can have significant effects. And 8 metres, I mean, most of the subdivisions that we'll be doing in the council's urban areas, residential zones, are about a minimum of 450 square metres or larger. If we impose the 8 metre access width, you're losing up to about 170 square metres of land from subdivision yield. That's about 38% of the minimum allotment size. So that kind of puts in perspective how excessive that is. If you came back to a 450 metre allotment with about a 3 metre access, you're still looking at about over 80 square metres of land lost to it. And for what purpose? There is no purpose that I can see. We have successfully, for many years, allowed services to go underground at 3 metres and at 3.5. There's really no requirement to go to 8. Services are generally put in the same trench at different levels, and there's really been no issues. Council talked about amenity as being potentially one reason for allowing, for wanting 8 metres. Unfortunately, I can't find any objective or policy or any discussion in any council document that links an 8 metre access league to urban amenity. It's a nice thought, maybe it's one of those preferences, but access ways are utilitarian in urban areas. Some are more beautiful than others, but they are utilitarian in basis, and that's their sole purposes for access and passing and repassing. perhaps in the country living areas or rural residential areas, you will find that people with much wider access, and that probably is for amenity purposes, certainly not required for services and for safe vehicle passing and repassing. We think also that, particularly on infill, and I've done a little bit of research on some of the current allotments within, for example, Ngātarewa Wahia, where you have a number of old allotments which are around about 1,000 square metres. They're generally quite narrow allotments at between 16, 17 metres at width, and potentially quite long. They also have houses on them which are generally located towards the road, and with at least only 3, maybe if you're lucky, 4 metres between any particular boundary. So immediately you would have quite a number of allotments that would typically fail this rule. And I guess my question is, well, how will council deal with that? There's quite a few allotments that I can see that still could be could be infilled and would foul off this rule for what I can see is no particular gain for 8 metres. And same with the greenfields. There's a lot of areas within the Ngātarewa Wahia residential zone that potentially can be subdivided if the owners desire to do so. And there would be at 8 metres, a very substantial loss of land and a loss of yield. And I don't think that's something that we should be looking to do for no obvious gain.
Mr. Barrett, can I just stop you there? Have you lodged evidence in support of what you're telling us?
No, this is one of the submissions, sir, that I didn't.
You might recall when I thought so. I wanted to give you the opportunity to say that I'd missed it, but we asked you before about providing us with written evidence when you were making, very substantive comment on a bunch of matters. Well, it's really difficult for us to appreciate what you're saying. We haven't had the opportunity to pre-read it. And, I think I impressed upon you the time before last that we weren't very excited about, another example of a long verbal statement that refers to a whole bunch of material that we don't have. So I'm going to ask you to wrap up quite quickly, please, because the continue on along this line isn't particularly helpful to us.
Well, I'm hoping that it would be helpful. I did not prepare in-depth evidence. There's some reasons for that, but I was under the impression I was allowed to speak for at least 10 minutes.
You've been considerably in excess of that. We understand the point that you're making about the road widths in table 14.12.5.14. You've made that point clearly, but all the additional information and cross-referencing and so forth, short of going back to the transcript, I mean, you can talk a lot faster than I can write, and all the extra information you're providing in the way that you have isn't helpful. Not that the point that you're raising isn't, but the way that you're presenting it makes it very difficult for us to follow the nuance of what you're saying. So I just...
Well, I can probably appreciate your position, sir. I guess then the final thing, I think there's some questions that need to go back to the council for justification for 8 metres. And that's really what I wanted to point out.
And we understand that point. We understand that you're questioning it for a number of reasons.
Yeah. So I have no more to say on that.
All right, thank you. Let's see if there's any questions. Mr. Cooney?
No, Mr. Barrett, can you give us a copy of your notes, and that'll be in. Have you got them there? You can send them to us.
Yes, sir, I can do that.
Yeah, thanks.
Good, thank you. Ms. Gibb?
No questions. I do understand your point. Thank you.
Mr. Fulton?
Yes, no questions. Thanks.
Ms. Tiaho?
Thank you, Mr. Barrett. We did hear a similar submission earlier, and we've got the letter from the Fire and Emergency as well, and we'll get the response from the reporting officer. So thank you very much for the points that you've made.
I think I've gone around the panel, haven't I? Yes, I have. And I've got no questions. Thanks, Mr. Barrett.
Thank you.
Next is Ms. Foley from the Regional Council, please.
Sorry, I'm having some problems.
Sorry, Ms. Foley, you're very faint.
Kia ora tātou.
That's better. Thank you.
Yeah, had my mic pushed up.
Thank you.
Okay, so I have also done a summary of a summary. So I will just go through it, and then if you've got any questions.
Thank you.
So thank you for the opportunity to present today. I am supportive of a number of the recommendations made in the Section 42A report for this hearing. And in my evidence, I highlighted 3 particular matters where I believe some changes should be made to better implement regional direction, and also to recognise the Regional Council's regionally significant flood scheme infrastructure. I'll also address the rebuttal evidence of Mr. Mackey, who authored the 42A report.
Thank you.
So my first area of concern relates to the low impact approach to stormwater management. So while I support the proposed plan's low impact approach, which requires best practice low impact design for new development or subdivision, I raise concern with a gap in the rule framework. So where a proposal does not meet the P1 activity standards and becomes restricted discretionary activity, discretion is limited in this matter. I suggested that an additional matter of discretion be included to close this gap to ensure that all developments are required to consider best practice low impact design approach to the management of stormwater, not just those that comply with the permitted activity standards. I note that Mr. Mackey in his rebuttal evidence agrees with this position and recommends an amendment to include low impact design principles as a matter of discretion. I support this recommendation. Secondly, I had concerns with the consistency of the provisions for identified areas within the infrastructure chapter. And so I supported the recommendations in the Section 42A report for the inclusion of additional permitted activity standards and new matters of discretion for identified areas in Section 14.2 transport, and the recommendation that 14.3.1.3 be amended to exclude earthworks from significant natural areas. However, I believe there to be still inconsistencies between the permitted activity thresholds and activity status within the zones, leading to my opinion that the RPS policy 11.2 and implementation method 11.2.2 regarding significant indigenous vegetation and fauna were not given effect to in the notified plan. I acknowledge that some activities have functional need to be located in or near SNAs, but these activities still need to be considered in the context of the whole of the method 11.2.2. I suggested setting thresholds for vegetation clearance in identified areas and consequently including a matter of discretion relating to effects on the values, qualities and characteristics of any identified area. I note that Mr. Mackey in his rebuttal evidence agrees with this position and recommends amendments to include permitted activity thresholds for clearance of indigenous vegetation within a significant natural area and a restricted discretionary activity for greater clearance. I support these amendments. So finally, I highlighted the need for a provision framework to provide for regional flood protection infrastructure. So the Regional Council's submission requested that Chapters 6 and 14 be amended to include a policy and rule framework to provide for the ongoing maintenance, repair, replacement and upgrade of flood and drainage scheme infrastructure. The Regional Council has a statutory duty under the Soil Conservation and Rivers Control Act 1941 to minimise and prevent damage to property caused by flooding. The Regional Council is a significant landowner and asset manager within the Waikato District. Flood protection reduces the likelihood of floods impacting on our communities and safeguards lives and property, enables productive use of land and protects services such as water supply, power, telecommunications and roading networks. Within the proposed district plan as notified, there is limited recognition of this significant infrastructure in terms of issues, objectives and policies, and only limited activities are provided for as rules. The permitted activity standards across all zones do not provide adequately for the ongoing maintenance, renewal and operation of the Regional Council's regionally significant flood scheme infrastructure. The proposed definition of infrastructure includes drainage systems and not flood protection. The implications of this is that the rules in Chapter 14, Infrastructure and Energy, that relate to infrastructure do not apply to WRC flood infrastructure, and there are no specific set of rules that do apply. The Regional Council would therefore be required to lodge non-complying resource consent applications for flood scheme related activities. Gaining resource consent would be an onerous and costly process, the cost of which may increase the level of targeted rates paid by those landowners who benefit from the protection afforded by the flood protection schemes. I requested the inclusion of a district-wide framework in chapters 6 and 14, similar to the treatment of the national grid infrastructure. This would also allow for permitted activity standards to be included for uses undertaken by other parties near flood infrastructure. I suggested a provision framework in my evidence. In his rebuttal evidence, Mr. Mackey has recommended including specific policies for regional flood management infrastructure and further recommended amendments to provide permitted activity and restricted discretionary activity provisions. I support these recommendations. In summary, I support the recommendations made in the Section 42A report as outlined in my evidence, and also the recommendations made by Mr. Mackey in his rebuttal evidence as outlined in my summary statement. Kia ora.
Thank you, Ms. Foley. Let's see if there's any questions. Ms. Gibb.
No, thank you. Thank you, Ms. Foley.
Ms. Tiaho?
So is it right that there's nothing left to be resolved in terms of the issues that you've raised?
That's correct. Yeah, I'm happy with the recommendations in the rebuttal and the Section 42 in combination.
Okay, thank you very much.
Mr. Fulton?
Yeah, no, I have no questions. I think you'll be pretty satisfied. Don't normally get the sort of statements that you've just made, so thank you.
And Mr. Cooney?
No, that's, thank you for getting that together and working that out.
Just one question from me, and you probably would have heard the questions I was asking Mr. Mackey, not about the merits, but just simply around how some of the points of submission have sort of found their way into policies. I take it that you don't particularly mind how the provisions that you've talked about are structured within the plan, provided that they're there in the appropriate place so that they can be pointed to. Is that right?
Yes, as long as there is a clear framework that can be applied for the flood management infrastructure,
yeah, okay.
then we're happy, and we're happy to be involved in any discussions to make sure that it is satisfactory to the council.
Yeah, because our point, or my point earlier, was simply that if you load something that's very specific, one sector, into a general policy, it can have the effect of not undermining that policy, but changing that policy of itself and the way that it's perceived.
Mm-hmm.
So
yes, we had suggested a separate policy.
Yes.
Mr. Mackey included our policy within another one.
Okay, so you don't mind. You're agnostic. Yep. You're agnostic on that. Okay, yep. That's fine. Yep. Very good. Thank you very much for your submission. It was very clear and very succinct. Thank you.
Great. Thank you.
Which brings us to Mr. Edwards for first gas, please, if Mr. Edwards is there.
Indeed. Thank you, Mr. Chair, and kia ora koutou. I will try and share my screen if that's okay, but just very briefly to introduce Nicola Hine, also from First Gas, so she'll be on hand to answer any questions you do have.
Thank you.
So I will, attempt to share my screen. If you just bear with me.
Maybe if you can delete the, or set it up in presentation mode with the little down the bottom.
Yeah.
There. Yeah. Then we get rid of the stuff on the left and we can see things a bit more clear. There we go. Perfect.
So yeah, look, firstly, thank you for your time. So just a very quick summary of the evidence that I've lodged. So very quick recap. The context for the evidence on the infrastructure chapter is really broadly related to the rural chapter evidence and linked into those reverse sensitivity effects and managing those effects. So that's, by and large, a lot of the context for my infrastructure evidence. On the infrastructure evidence itself, look, there is a large measure of agreement with the officer report recommendations, but there are a couple of amendments sought. And very quickly, they are firstly to include a definition of gas transmission network as the first point. So the basis of that really is to acknowledge that not all a network is the pipeline. So in a broader sense, we have above ground infrastructure, commonly referred to as gas stations. And there are 10 of these gas stations within the district, and they comprise compressor stations and delivery points. So it's really that inclusion of the definition to acknowledge and recognise that. And there is a reasoning behind that, which I'll explain in a few moments. But the second point really is to have those above ground infrastructure or gas stations illustrated on the planning maps in addition to the pipeline itself. So that's really is the second point in my evidence. As I said before, look, it links into the rural chapter evidence and managing those reverse sensitivity effects. And when I sort of link it back to the policies and objectives, really what this is achieving is well, the guts of it is really objective 616, which is very clear to protect infrastructure from reverse sensitivity effects, and that it's not compromised in effect. So that's what we're trying to achieve here. In terms of gas stations, just a couple of comments on that. So the gas stations are above ground infrastructure, so effectively where the pipes come up from the ground. So they're not submerged, they're not buried. The nature of those activities that happen at those above ground sites can be venting, which is the release of high pressure into the air. And Nicola will perhaps give an overview of that. But with that as well, that comes risks. But there's also, odor emissions as well. So they put a natural or an odorant in the natural gas, which is non-detectable in its natural form. So because there's no land covering and there are these activities, there is a different risk profile for gas stations beyond just the pipeline. So I don't think it's appropriate to lump in those above ground stations with the pipeline. And also then there are maintenance activities that occur at gas stations as well. So you get a lot more activity and it's visible, which again is different from just a pipeline. So Nicola will talk us through an example of one of these above ground stations.
Yeah, hi. So the photograph you can see there is from Tuakau North mainline valve. And so that's an example of where venting has occurred, possibly due to maintenance or operation requirements. We generally don't vent unless we really have to, because it is money in the air, but it can also be an emergency requirement as well. So I'll just briefly run through the types of above ground gas stations that we have. We have a delivery point, and that is the point in which the transmission pressure gas will be depressurized and becomes available for distribution to homes, communities, industrial uses, hospital, things like that. The mainline valve is a lock point in a pipeline, and this is required under our operating standard AS 2885. It's a safety requirement so that in the event of emergency we can compartmentalize the gas in the pipeline at certain lengths. So depending on the adjacent land use, might be that might have to have one every 20 k's if there's a sort of a sensitive activity occurring, like a school or something nearby. So those are a safety requirement. And a compressor station is where we, so over the length of the pipeline, the gas reduces pressure, and pressure is obviously important for distribution. So a compressor station generally houses some turbines or engine facilities so that we can reboost the gas pressure. And those sites can all, we can have venting from those sites. So you've got some of the noise, some odor, not all our pipelines are odorized. And so they're generally allowed, and just basically facilities where we do undertake maintenance operations. And here is an example, I guess, of why we are getting more involved in the resource management space compared to our predecessors. So First Gas was sort of Vector and NGC previously. This is Clevedon mainline valve. So the mainline valve, just to recap, is a safety sort of lock point in the pipeline, also an area where we can sort of depressurize and vent. The larger building you can see immediately to the right, I guess, or west, is a childcare facility. And then you can see different apartments that have been built up in the last few years. And so what First Gas has decided based on a safety risk profile is we will no longer vent from this activity, from this mainline valve Monday to Friday because of the childcare facility. So instead, if we need to, we'll do it on a weekend, which obviously has different implications for the adjacent homeowners there. So that's why we are getting more involved in these resource management, the resource management space.
So all right, thank you. That's helpful. Mr. Edwards, is that?
Yes, that's it. Yep.
That's what you wanted to say. Thank you. That's very helpful. Thank you. Let's see if there's any questions. Mr. Cooney.
Can you flick that back up again, that example of the childcare centre?
Oh, sorry, I was premature.
I guess while we're doing that, this sort of shows traditionally the pipelines were installed in rural areas in the 60s, 70s, 80s. And then obviously in Auckland, we're having to respond to urbanisation.
So in practice, what are you seeking to avoid that to happen again?
So in terms of the provisions in a plan, so if the provisions that we're now seeking were in the plan, they have been sought in the rural chapter, but what that would trigger is a kind of requirement for a resource consent in such close proximity to the gas station. So that's outlined in my rural chapter evidence, but this is, I guess, all part of the definition and the illustration on the planning maps, which have sort of kicked in this infrastructure chapter.
So if you need, because of the distance, etc., you need to apply for resource consent, what do you seek by way of that resource consent, by way of mitigation?
I think it's really dependent on a case-by-case basis in terms of what the activity is, how intensive it is, and if operationally that can be worked around. But I guess the key thing is to enable that conversation with First Gas as the owner and operator of that network. They are the specialists in that field, and so there are quite obvious risks around high pressure gas. And so it is, in many ways, largely a mechanism to have that conversation, and that conversation sometimes doesn't get caught. That's an evolution in terms of how First Gas now are approaching these sorts of land use issues.
Yeah, I'm just sort of more interested in what the final outcome is likely to be, and the nature of any requirements or restrictions that are imposed on adjoining landowners in that situation. So are you able to clarify that?
Yeah, I'll be able to sort of embellish a bit more. I guess what Hal's saying is by having the opportunity to have the conversation. So to use this scenario, for example, we might have to look at our own practices. So rural pipe was traditionally a thinner walled pipe, where we now have urbanisation that gets a bit technical, but basically in our AS 2885, we have to classify the adjoining land use. So rural R1 and R2 and urban T1 and T2, and also sensitive land uses need to be captured. And so in this case, the childcare facility is a sensitive land use, and the apartments there would sort of become, I guess, maybe T1 or T2. And then what we might do is look for to replace thin wall pipe with thicker wall pipe. That might be a worst case scenario, or we might use concrete slabbing, or we'll suggest an offset, a safer separation distance. So for in this instance, perhaps no childcare facility there, perhaps look at, a couple of 100 metres down, or look at distancing housing a little bit further away if possible. I believe we're quite enabling where we can be, and we will look to protections along the gas line also.
So if you're established there first and the land adjoining you is zoned rural, but then it becomes, it's rezoned, sorry, it's rural, but it's rezoned residential, do you oppose that rezoning, or do you bring it up at that stage, or what?
So I guess first gas, our approach is to seek rules in, like that, in your example of residential chapter, which provides us with the mechanisms to be involved, because without the resource management rules, we actually don't get to have much of a say. We only have the pipeline easement, and that's the sort of more at the property law, the landowner interface. Yeah.
I think so that, sorry, so I think that really strikes at the heart of the issue that First Gas is dealing with here. In that, you know, there is this incremental development on land that contains the pipeline, but was never sort of protected against that sort of land use. Traditional reliance on the easement, you know, it's kind of a thin corridor. It doesn't take into account or cannot sort of, or was never intended to manage those broader reverse sensitivity effects beyond that immediate easement. So it really does strike at the heart of the issue that First Gas is dealing with.
Yeah. Do you have these gas stations built much in the rural areas, or is it mainly in the urban areas?
They're mostly rural. Some are urbanised as a result of urbanisation coming later, but mostly rural.
Yeah, okay. Thank you.
Thank you.
Thanks, Mr. Kenny. Ms. Tiaho?
No, nothing from me. Thank you very much.
Ms. Gibb?
No, nothing from me. Thank you.
Mr. Fulton?
Just the, when you talk about, I think what you've said here is that you have one in Te Kowhai, the air park zone. Is that correct? Is that the only one you have that's in this category?
Oh, sorry.
You've talked about rural and country, but you've talked about Te Kowhai air park zone.
Yes, we have. I see we have off-take and possibly delivery point.
Okay.
I have to check the extent of the zone, sorry.
Yeah, I think, I'm not 100% sure on that, sir. I mean, certainly the gas pipeline goes through that airport zone, but I'm not sure if an actual above ground delivery point does also. The indication is that it does in terms of the original submission rather.
Okay, that's maybe interesting later on when that comes up for a hearing. Okay, so I just want to establish how many of these outlets there were, but there doesn't appear to be a lot apart from your gas transmissions. That seems to be the main area, isn't it?
In all, there are 10 above ground gas stations within the district.
Yeah.
Yeah.
Okay, thank you. I'm happy about that. Thank you.
Thank you. And I have no questions. Ms. Gibb, I think I asked you, didn't I? I'm assuming I did. And I've got no questions. Yes, I did.
Thank you. Sorry.
Thank you. And I've got no questions either. Thank you both.
Thanks for your time. Thank you.
That brings us to the end of the morning session. What I'm going to ask people to do is that there's a separate meeting request for this afternoon session that you'll need to log off from this one on and log on to the afternoon session link that you will have if you're part of the hearing. So we'll adjourn until, let's say 1:15. We've got a scheduled half-hour lunch, and we'll maintain